May I have your lordship leave to move an extremely urgent matter?
Highly please.
My lord,
Doctor,
my lord, may
Your lordship, kindly
leave to move an extremely urgent matter?
kindly allow me.
This leave may be-
Yesterday, leave was granted by your lordship, my lord. The matter will infructuous, my lord. I have filled up the form fill up within due course. Only 500 rupees, my lord, I could not pay. Your lordship has granted me leave. Matter is appearing at 607 yesterday, my lord. It will take, my lord, only, my lord, only it takes, my lord, only 1 minute time, my lord.
Well, yesterday it was 10:30 matter. Today, Mala, it is missing from the list up to 6. We waited for the whole day. But up to 605, 607, it was yesterday's list. It has not been printed.
One number no. What is your matter?
607, up to 605, it was called yesterday. Today, Mala, it
It will be
is.
taken up in the after the vacation. It will be taken.
Mala, but the admission process, Mala, the participation in the selection process, Mala, if the list is published, we will be out, Mala. My application was tendered, my lord. Fees was not due to the server down, my lord. The fees did not reach them. They agree, my lord. I had a talk with Mr.
Where is Mr. Sannal?
Mr. Rahul Vishwas is. Ratul Vishwas is.
Ask him to
Mala,
remain present.
At 12 o'clock, should he come?
12
Kindly,
o'clock we'll see.
kindly, permit. At 12, Mala, let us come back.
You give your number.
Yeah.
This is the same number. Same. Mr.
Yesterday's
He's
607.
appearing with you.
Yes, we are both are together.
Okay. Ask Mr. Biswas to remain present.
As you lordship.
এইটা
Okay.
শুধু দিন তো আপনি সাপ্লিমেন্টারি লিস্ট করে রেখে 12টার সময় রেখে দিন ঠিক আছে
Grateful. Deeply obliged to lordship.
leave may be granted to move the vacation bench at least, my lord.
leave granted to move before the
Vacation.
vacation bench.
My lord, kindly grant me leave, my lord, to move this matter before the vacation bench, my lord. It is not appearing in the list, my lord. MSK matter only because on 1st of January, my lord, the matter will infructuous. Your lordship has passed an order, my lord, to revert back, my lord, to the post of Samposarok, my lord. On 1st of January, my lord, the EPF has been granted. They are allowing this bargain, but I shall be deprived to getting my 5 years of service. Similar matter, only costed is equal to be similar order, my lord, will you passed. You know, kindly take up this matter 10:30 tomorrow, my lord. It event takes, my lord, 30 seconds, my lord. Only the costed is equal to be changed, my lord. Similar order, my lord, will be passed by lordship.
How many?
Only one matter, my lord.
Give.
Matter is matter should be listed on today, my lord, but it has been listed, my lord.
It will appear tomorrow.
At 10:30. Yes.
But if it's similar, then only.
Similar, my lord.
If some other issue is cropped up, then it
No,
will
my
be.
definitely, my lord. I could not make this submission
Huh.
before lordship. Only costed is equal to change. Similar order, my lord.
এগুলো স্পেশালি বলছে সেগুলোই থাকবে শুধু কালকে
Mala, extension can be taken up before 10:30. Other side is there.
লেট মি ডেলিভার দিয়ে দিয়ে দেখো আন্দামান
My lord, my senior is for the appellant, my lord. I am appearing on behalf of my senior.
My lord, in this matter, my senior is appearing on behalf of the respondent, my lord.
you are appearing for whom
I am for appearing for Jaipal, my lord, the appellant.
and madam is appearing for
For N.A. Khan, London Advocate N.A. Khan, respondent, your lordship.
okay both the appeals FMAT 2 of 2024 and 3 of 2024 are dismissed.
Oblige, my lord.
Obliged, sir.
The impugned judgment of the first appellate court is affirmed in both the appeal.
Obliged.
Oblige, my lord.
পাঠিয়ে দিন দাও এক্সটেনশনটা ডেকে নিন একটা সাপ্লিমেন্টারি 12টার সময় হবে আজকে 12টার সময় একটা কি বললাম না
কাগজ নিয়ে আনতে দাদা এই নাম লেখ একটু কাগজ দেবে আমার আর শ্রমিক
One, for the petition.
And for the state, madam.
The interim order was up to 30th.
I am filing my opposition. My lord, I am strongly opposing the the prayer for extension of interim order because my lord, during vacation, my lord, this order was passed. My lord, the teacher concerned, my lord, due to scarcity of teachers, my lord, she was transferred to my lord, nearby my lord, school, my lord, where there is one teacher, 44 students. My lord, in terms of the my lord, in terms of the my lord, school education department my lord, direction, because in West Bengal more than 22,000 my lord, schools are running with scarcity of teacher. That is why my lord, for my lord, in terms of the my lord, school education my lord, direction, we have my lord, reallocated some teachers. My lord, here my lord, 532 my lord, students and my lord, 72 teachers. My lord, excess teacher, that is why she was transferred. My lord, in before he moved it before vacation bench, well, vacation bench observed that since my lord, cessation of school my lord, during my lord, puja vacation, that is why 1 month stay was granted. My lord, directed to my lord, file opposition. I filed my opposition disclosing all facts. My lord, kindly fix it after vacation in any day. My lord, I am only my lord, praying before your lordship not to pass any my lord, entry order for independent prayer. Kindly fix it.
Advocate for the
Otherwise, school
affidavit
will
of
be suffered.
affidavit in
Student will be
opposition
suffered.
filed on behalf of the behalf of respondent number 4 and 5 is taken on record. Copy served. Next line affidavit in reply filed on behalf of the petitioner to the affidavit in opposition of respondent number 4 and 5 is also taken on record. Taken on record. Para. Mr. So and so learned advocate for the petitioner seeks for extension of the interim order granted earlier on 3rd October 2025. Such prayer for extension of interim order is opposed by Mr.
School Council Nadia.
Opposed by learned advocate appearing for DPSC Nodia. On the ground that the petitioner has been transferred to maintain the student-teacher ratio. There is excess teachers in the present school.
Yes,
There
yes,
is
yes.
excess teacher in the present school where the petitioner is posted. He seeks that the matter be fixed for final hearing. You are appearing for state.
No, in second matter, my lord, similar matter.
In view of the submissions advanced, the interim order granted earlier on 3rd October 2025 is extended till the end of January 2026 or until further order, whichever is earlier. List this matter. 3 সপ্তাহ পর date transfer এর দিনে বলুন. This is transfer petition.
Transfer petition.
Transfer এর দিনের date. List this matter on 22nd January 2026.
Very good.
Grateful, my lord.
Yes.
No, next matter daw. My lord, in the
To, in spite of direction, no opposition. has
my
been
lord, I shall file my opposition, kindly extend it.
No,
In
no,
the meantime, I shall
the-
complete it.
DPSC.
DPSC, this is my lord, Jhargram.
Mr. So and so learned advocate for DPSC Jhargram seeks extension of time to file affidavit in opposition.
On the same date, it may be fixed, my lord. In the meantime, we shall complete
Okay.
all these affidavits.
Let such affidavit in opposition be filed within 2 weeks of reopening of the court. After
Within 1 week, my
notification.
lord, I can file it. It is almost ready.
Within 1 week. Reply if any be filed within a week thereafter. Mr. Learned advocate for the
may I
petitioner
take
seeks
this
for
as
extension of the interim order. In view of the above, the interim order granted earlier on 3rd October 2025 is extended till the end of January 2025. List this matter on 22nd.
Lordship.
Or until further orders. No, no, please read petition.
Sir.
এই শ্রীমানি বাবু কালকে সুরিত বাবুকে না একটু ওই পে অ্যাপ্লিকেশন এমএসসি অ্যাপ্লিকে দিয়েছি আমার এই আগের অর্ডার গুলো থেকে একটু
610.
করে দিন।
My lord, in this
My lord, I
matter,
am for the petition, my lord.
I am for the district primary school council.
And for the state lordship.
There was a direction to file report,
Yes.
my lord.
610.
Yes,
610.
এটি 10:30 অন্য কোর্টে যেতে চলে গেছে নাকি? Where is the report?
My lord, this is my report, my lord, on the in pursuance of your lordship's order dated last order, my
May I
lord.
get a copy of
This is
the
the- My lord, I am supplying you a copy, my lord. My lord, this is the report. It was filed before the actually, my lord, Commissioner of School Education. And after perusing this report, my lord, the Commissioner of School Education has passed the, my lord, impugned order herein, and my lord rejected his application for compassionate appointment of her compassionate appointment because her monthly income exceeds, my lord, the Group D employee of the central government.
Monthly income.
Yes, my lord.
What is her monthly income?
But in the
That is
impugned
the,
order,
my
my lord, they have calculated, my lord, page 40, my lord, internal page 3, my lord, that the petitioner is having additional income of amounting to rupees 7,000, my lord. They had relied upon a report, inquiry report of the council, my lord, that copy was never served, my lord, and so that we could not, my lord, my lord, raise any
Did the
objection.
party appear before the
No hearing was, opportunity of hearing was granted, my lord.
then? So was there any earlier writ petition?
Yes, my lord. Pursuant
Yes,
to
my
the
lord.
direction of the honorable court, my lord.
My lord,
So what was the direction?
My lord, page 35 is the order passed by this honorable court. My lord, internal page 2, paragraph 7, my lord. In the above circumstances, this court directs DPSC Paschim Medinipur to ascertain the factors as enumerated herein above. For the said purpose, conduct detailed inquiry, let report to police.
35.
My lord, 35 is the
35
order starts from page 35, my lord.
To ascertain the factors in
Page 36, the
and
detailed inquiry.
yes, 7.
appropriate decision in the matter. If the decision is in favor of the late, appropriate recommendation be sent to the chairman of the DPSC, who shall appropriate steps if necessary by referring the matter to the board of primary education and board of secondary or to the DI secondary as the case may be.
Accordingly, this report was, my lord, submitted before the Commissioner of School Education, and on the basis of this, my lord, the report and the Commissioner of School Education has considered and passed the impugned order, my lord.
You like to file any exception to the report?
But it is not in the form of affidavit, my lord. Kindly please, my lord, I cannot, my lord, use any
No,
reply.
because of that report in the order sheet, only to file the report,
Yes.
that report, which was filed before the, if your lordship directs me, then I shall file an affidavit in opposition by annexing this
What is,
report
what is
also.
the profession of this petitioner?
But the petitioner is widow, married daughter of the deceased teacher.
Okay. He works in any organization?
No, my lord, no, my lord.
And how this income is calculated?
But that calculation is also, my lord, not never disclosed, my lord. My lord, I'll be, my lord, praying, my lord, the commissioner may be directed to take a decision afresh, my lord, upon giving opportunity of hearing and by furnishing the inquiry report, my lord. Since it violates the principles of natural justice, my lord, but since no
And
hearing.
in my report, my lord, at page 3, my lord, I have, my lord, it is annexed, my lord. And my lord, here, my lord, at page 4, my lord, it is categorically, my lord, total family pension, it was taken into consider, and thereafter deduction, that is 40% deduction from that amount.
Yes, my lord,
How, my lord, some other income from month for her family, that is 7,000. All this, my lord, everything, my lord, it is the 7,000 which has been stated here, my lord, which has been, my lord, this 700 also they have produced all these documents before the, my lord, their documents, on their documents, my lord. And it is from pension payment order. 40% was taken into consideration plus 7, my lord, it exceeds, my lord. This is clear report, my lord. It was considered before the. If your lordship, my lord, directs us to file one affidavit on opposition, we shall
Wait. Who is Manoshi Patro?
But the widow.
Who is the applicant?
But the married daughter.
Mother has not filed
No.
any application for compassionate appointment.
No.
She has crossed the age
She has crossed the age, my lord.
or given a no objection to the.
Yes, this is the system, my lord. This is the procedure, my lord. All the years, if any other years, my lord, they will also give the no objection, my lord, to that effect.
But from their report, it appears, my lord, the Pradhan has.
Where is the income of this petitioner? How have you inquired and come to this conclusion that she has a total family income of 16,000? Where from are you getting that?
My lord, the from the pension payment PPO, my lord, pension payment order, my lord, the first portion, that is amount of pension, my lord, it was, my lord, it was taken into consideration 9,194.
But if 9,000 is taken into consideration, then it comes under below the gross salary income of the group.
Thereafter, from other income, my lord, family, other source of income of family per month, 7,000. This 7,000, my lord, they have, my lord, produced documents from the panchayat.
But there, my lord, it appears from their document which was issued by the Pradhan, my lord, that only, my lord,
It is not our document. It is everything is supplied by them.
Yes, my lord.
If you lordship clarifies, then I shall come with one affidavit in opposition.
Page 9, my lord, kindly see, my lord. Only source of income is the, my lord, the pension. And next page also, my lord, the
At the time of compassionate appointment, the pensioner's amount is also taken into consideration?
Yes.
So what is the Manoshi Patro? What is the amount of pension she is receiving?
My lord, it is, my lord, the after deduction, my lord, 9,194. Which is below the gross salary of the group D.
My lord, PPO I have annexed.
Now we place the rules under which this is taken into consideration where compassionate appointment is given.
But the 2009 rules, my lord.
You have that rule?
But the rule, my lord, of note 33(1) AC, my lord, dated 26 June 20.
Where is rule you are not carrying? But how do they reject your prayer on the basis of this? They say that it is more than what Group D employees.
Yes, but that 7,000, the calculation, my lord, that inquiry report they have.
Report filed by the DPSC, Paschim Mednipur is taken on record, copy served. Learned advocate for the DPSC Paschim Mednipur submits that the family income of the petitioner is more than the gross salary of the Group D employee. On such ground, on such score, the petitioner is not entitled to appointment on compassionate ground. He seeks to file affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within a period of 2 weeks. A reply winter vacation, right? 2 weeks, 1 week, 3 weeks for a list. Get the rules also on that date. You file your reply so that you can also refute. 3 weeks for it. This will come under miscellaneous.
Miscellaneous.
Get Lordship.
না 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 এই মিসেলেনিয়াস আর আলাদা করবো না বড় না হলে it will appear in motion.
I am appearing.
I shall come with the rules.
I am appearing for the state lordship. State.
Yes.
State. I am appearing.
My lord, I am for the petition.
Lordship, I am for the respondent, NIOS.
Last occasion, your lordship directed
My
me
lordship.
to serve notice upon the NIOS. My lord, I have given. My lord, my learned friend is representing on behalf of the NIOS. My lord, this is my affidavit of service.
My Lordship, I am led by Mr. Shiv Shankar Banerjee. Kindly grant me a short password, my Lordship.
Yes.
Kindly grant me a short password, my Lordship. I am led by Mr. Shiv Shankar Banerjee.
You are appearing for whom?
For the NIOS, my Lordship. For the NIOS.
But pattern is very urgent in nature. My lord, tomorrow, 25th is the last date for filing application of my lord 6-month PDPET course, which has been notified by the NIOS.
My Lordship, a short password.
Tomorrow is the last date.
25th.
25th.
Last
What is
date
the
of
prayer?
extension,
Will you come?
Huh, my lord?
What is the prayer?
My lord, prayer is, my lord, petitioner joined in their service as a primary school teacher with their B.Ed qualification. My lord, 2016 selection process, B.Ed is not the actual training qualification, rather than DELED is the actual qualification. Now, after my lord, joining, petitioner joined as an untrained candidate. Then the authority said you have to complete the training qualification by 6-month PDPET course. My lord, NIOS made an advertisement for 6-month PDPET course. Your lordship may turn that page number 31. Page number 31 of my writ application, my lord, once, my lord.
This has to be completed within which period?
6.
No. As per the decision in Devesh Sharma,
Devesh Sharma, my lord, subsequently come. It has Devesh Sharma filed by the B.Ed or B.Ed versus DLED. DLED candidate says no B.Ed. My lord, Devesh Sharma came into play in 2018 by NCT notification. When B.Ed, my lord, we have participated basis of prior 2018, where only DLED is the valid training qualification. Subsequently, NCT changed the rule. 2018 rule, it has been said B.Ed is the also valid training qualification. Then, my lord, DLED filed.
where is he?
My Lordship, he was present in this court. A certain matter has been came up in another court.
Ask him to come.
Sure, my Lordship.
10 minutes past over. 10 minutes
Much
more.
appreciated.
The board is there. Oh.
For the petitioner, I want to withdraw this petition with liberty to file appeal. There are certain
Written instruction. Written instruction.
written instruction I have not yet get. Then kindly keep it after vacation on the date. I will file my written.
This matter is appearing under the heading to be mentioned. Learned advocate for the petitioner seeks accommodation. Submits that the petitioner does not intend to proceed with the present writ petition. He seeks accommodation to file a written instruction. Release this matter 1 week after the vacation under the same heading.
Relates to overdrawal, my lord. Overdrawal. My lord, mother of the petitioner was the teacher. My lord, she retired in 1995. Thereafter, she died on 2020.
Why it is appearing under to be mentioned?
Appearing as to be mentioned or motion?
To be mentioned কেন দিলাম? ও এই বারবার ও অপশন 1 এটা কত নম্বর আইটেম 4 আগেরটা 3
ডাকতো এটা তো
yes
petitioner's mother was the teacher. She retired in the year 1995 and died in the 2020. PPO was issued in the year 2001. Can you see the PPO? My lord, overdrawal amount was deducted after the issuance of PPO, my lord. Can you see, my lord, page 11, my lord? Page 11, my lord, can you see, my lord, at the middle portion, my lord, right hand side, amount heading is there. The last column, overdrawal 39,894.
He retired on which date?
Retired on, my lord, 30th June 1995.
Yes.
I am for the statement.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for you are seeking for cancellation of the pension payment order or refund of the amount?
A refund, my lord, can you concluding part, my lord?
Why did you write that for cancellation of the pension payment order?
Since the pension paper shows the overdrawal amount, my lord. That's why, my lord, only refund, my lord.
By the present writ petition, the petitioner seeks for a refund of the overdrawal amount of rupees 39894 deducted from the retirement benefits of petitioner's mother on the alleged ground of overdrawal of pay. The petitioner contains that her mother was an assistant teacher of Panchanon Vidya Niketan, Karimpur Circle, Nodia. Stop. After discharging continuous service of 33 years, the petitioner's mother retired from service on superannuation on 30th June 1994. The pension payment order was issued on 16 January 2001. Stop. The petitioner's mother died on 24th February 2020. After lapse of almost 8 years, no, 7 years, the overdrawal has been deducted. 7 years of retirement period. The overdrawal has been deducted at the time of issuance of pension payment order. Being aggrieved and dissatisfied with the action of the respondent authorities, the petitioner has preferred the present writ petition. Mr. Bari, learned advocate appearing for the petitioner, submits that such deduction of overdrawal, relying on the decision of Honorable Supreme Court passed in State of Punjab versus Rafiq Masi, he submits that such a deduction of overdrawal of pay after a lapse of 7 years of retirement is impermissible in law. He seeks for a refund of the said amount together with, have you paid for interest? Together with
Yes, ma'am.
interest. Learned advocate for the Mr. So-and-so, learned advocate for the state, leaves the matter to the discretion of the court. It is found that the mother of the petitioner has retired on 30th June 1994 and the pension payment order was issued in her favor on 16 January 2001. At the time of grant of pension, an amount of rupees 39894 has been deducted as overdrawal in pay. Para. Now it is to be examined whether such deduction towards overdrawal of pay is legally sustainable. Para. At this stage, it will be apposite to reproduce the relevant paragraph of the observation of Honorable Supreme Court in Rafiq Masi Supra, para 18. আগের এটা করা আছে। In view of the proposition laid down by the Honorable Supreme Court in Rafiq Masi Supra, it is found that the refund towards overdrawal in pay is impermissible. Who will refund this amount? Which respondent? Accordingly, the respondent number
Treasury official. Respondent no 4 and 5.
Treasury cannot do this. Which office has deducted this amount?
Pension payment order was issued by the Director of Pension and Provident Fund. But after deducting the amount, pensionary benefit was released by the concerned treasury officer.
So he has not been made a party, and director has not been made a party. একদম topic on the prayer of the learned advocate for the petitioner, leave is granted to implead Director of Pension and Provident Fund. You do it. The as added respond number উনি হচ্ছেন 6. According Director of Pension is directed to refund the amount of rupees 39 বলে দিচ্ছি কত 39894 together with interest at the rate of 8% per annum from the date of issuance of pension order, that is 16 January 2001, till the date of actual payment. The payment shall be that such refund shall be made within a period of 8 weeks from date of communication of this order. With the aforesaid direction, writ petition disposed of.
Only one small correction, in the body of the petition, I mentioned that 30th June 1994, mother retired. It will be 1995. Instead of 1994, it will be 1995.
On the prayer of learned advocate for the petitioner, leave is granted to which paragraph? Leave is granted to correct the date of retirement of the mother of the petitioner in paragraph number 2 of the writ petition.
My lord.
Get
for the petition. On last occasion, your lordship was pleased to grant some time to the state to file the report. My lord.
Yes.
My lord, I have filed the report. My
You are
lord. Here the issue is my lord, the father of the petitioner was an employee of a training center. He died, my lord, his service was approved in the year 1992. Subsequently, my lord, he has crossed the age of superannuation, but no pension has been disbursed. In 2023, the father of the petitioner has died. The petitioner is a widow daughter who claimed pension as well as my lord, family pension. Now, till today, no pension, family pension has been disbursed. Your lordship, kindly come to page 13 once. Page 13, 1-3. Now, this is an order issued by the Director of School Education by which the service of the father of the petitioner has been approved. Serial number 3, Sivadas. Page 1-3.
That's to be.
1-3.
1-3 of my repetition.
Yes.
3 persons has been approved, my lord. Torongo Prabha Roy, Dikpote Mishra, Shiva Das. 2 others have already retired, they got their pension, except the petitioner. Now, in 1992, this school was closed due to shortage of student. But that is at page 14. And the father of the petitioner was directed to keep in touch with the office of the District Primary School Council, Malda. Subsequently, he has crossed the age of superannuation, but no pension has been disbursed. Thereafter, he died in the year 2023. The widow daughter claimed pension as well as family pension. Now, the stands taken by the District Primary School Council as well as the state that no service record is available. Well, all my attendance sheet and other service documents should be lying with them. It should be in their custody.
And the service book?
But I have the document, I have the, my lord, the notice of superannuation. But may I permitted to file a supplementary affidavit to bring it on
And the
the
service book?
that is also with them. My original service book should be lying with my service
The
record.
copy of the service book is also with the employee?
But
Yes.
the duplicate service book should be lied with the employee, but I don't have find that. After demise of my father, I do not find any document of regarding my service book and others. Only documents I have the letter of approval as well as the subsequent letter by which he was directed to keep in touch with the office of the District Primary School Council. That is at page 14. And I have got received, my lord, recently I found the document of my lord, notice of superannuation that I can bring into record by a supplementary affidavit.
Find out.
Lordship.
My lord, in the earlier occasion,
By the state.
my lord, we have filed a report, and today the state has also
Both
filed
have
a
taken
report
the same stand that no
because,
service
my lord,
available.
we have where, my lord, the section that is basically charged with this record and other acquaintance role salary, we have made a thorough inquiry. My lord, nothing, not a single scrap of paper related to the petitioner, my lord, is found on those section. My lord, this may be a case that after attachment, this person, my lord, subject to correction, this person could not attend his service.
That be so.
And 2009, as per my learned friend, my lord, submission and the statement of the writ petition, 2009, the father superannuated. Now, 2024, the writ petition filed by the widow daughter, my lord, widow daughter, 2009 since 2024. And it is our, my lord, specific stand because we have taken all possible steps because it is a case of pensionary benefit to search out any single scrap of paper. Not a single scrap of paper, my lord, is coming out from the related section, and it is also the stand of the as my learned. No, nothing, my lord. It shows that perhaps this employee, my lord, after his service attachment, he did not perhaps turn up.
If that be so, then till the last date on which I attend the office, that service record should be there. If I did not
My lord,
attend the office,
if my lord, petitioner is not at all, he
time, then they
did
should
not
take
join
appropriate
the
steps
service.
against me. But the service record. should be there.
1992, my lord, as per the annexure of the writ petition, my lord, page 40, that initially he was in a other employment, thereafter it was attached to the office of the council. Now 1992 onwards, my lord, not a single scrap of paper we are, if a person is attending, if a person is drawing salary or having, my lord, regularly attending, then the acquittance roll, salary slip will be there. Nothing is there. And it is also, my lord, that perhaps my learned friend would say the same thing because they are taking the same stand. DI of school, who is the pension sanctioning authority, he is also saying, my lord, not a
A
single.
letter has been issued.
Yes,
He
my lord.
says that a letter has
Let
been
it
issued.
be placed on record, then we will try to let it be placed on record.
But then again, no steps were taken from the side of the DPSC that since you are not attending the office since
Malote-
long, so we are going to terminate your service.
Malote,
My lord, after attachment, he probably he did not join the service, my lord. That's why no record has been found, my lord.
But they should produce the documents relating to
An
attachment.
advocate for the petitioner. The report filed by the District Inspector of Schools Primary Education Malda is taken on record. Learned advocate for the petitioner submits that the petitioner was the father of the petitioner.
Father of the
yes.
Father of the petitioner, namely Shiva Das, was appointed as a non-teaching staff of Pipla Mother Training Center. However, the said training center was closed and he was attached to which school?
Malote,
I was directed to keep in touch with the office of the district primary school
And
council.
his service was attached to the District Primary School Council, Malda.
Malda
yes, my lord. As per
Malda.
the DI Malota memo.
of 1992.
In the meantime, the petitioner father, petitioner's
There are
father,
two institute name is two
Sir, wait,
institute
sir.
mentioned.
petitioner's father retired from service on superannuation on which date?
In 2009,
In the year 2009. A communication has been received
Communication.
from District Primary School Council.
district primary school council.
District Primary School Council for processing the pension papers of the father of the petitioner. He seeks leave to file supplementary affidavit in order to submit the said document. Leave granted, let the supplementary affidavit be filed. ওপরে report file বললাম না?
Hello, report filed by the state.
কোথায় গেল report? Supplementary affidavit be filed within a period of 2 weeks.
Okay.
This matter after 2 weeks. 2 সপ্তাহ পরে একটা ডেট দিন।
And Malot, in the previous order passed by this honorable court, Malot, just I want to point out, the petitioner has been directed to cooperate so that we can do something. Now, Malot, if that be there, he should produce that thing to us. Let it become. I'm grateful to you, Lordship.
First to 28661.
28861.
No one is here. No petitioner is there.
চেঞ্জ হয়ে গেল তো লোক। আমি তো
তুই কি রেসপন্ড
হ্যাঁ হ্যাঁ NIS
Should I want to participate? PET course.
Yes, what is your case?
Page 97. Last date 25th December 2025 for registration. Lordship, 3 times I will be allowed for the examination, but I have allowed for once. Second time when I applied,
Petitioners are all appointed.
I'm covered by the judgment at page 80.
What is your fact? Will come up judgment later on. What is the fact? The petitioners are appointed in the school,
Yes, yes.
in the government school.
Is working in a primary school.
Okay. Now, what is the difficulty? Yes.
My lord, petitioner before your lordship is, my lord, assistant primary teacher who have joined in their service in respect of 2016 selection process. My lord, they at the relevant point of time, petitioner do not have the, my lord, DELED qualification, which is the requisite training qualification, which has been advertised by the board. Rather than petitioner has the B.Ed qualification. Accordingly, my lord, in the advertisement, it has been stated who have not the trained candidate, they can join the service as untrained candidate. So petitioner, since they have not the requisite training qualification, petitioner joined their service as untrained candidate. Now, board, after joining, my lord, board, my lord, it is the obligatory on the part of the petitioners to become a trained candidate. Now, petitioners admitted in 6 months BP PDPET course, 6 months bridge course. My lord, kindly see that advertisement once, my lord. Page number 70, my lord, page number that is 31, my lord. That course is, my lord, running by the NIOS. My lord, 31, kindly see. 31, my lord, it is certified course, certified in professional development program for elementary teachers, PDPET, also called DELED bridge course for B.Ed in service primary class 1 to 5 teachers. So this is the bridge course, 6-month bridge course. But it has started in the 2017. My lord, now it has been, my lord, reappearing. There is an obligation on the part of the authority to re-examination, reappearing in the examination. My lord, kindly turn page number 72. That's the continuing part. Page number 72 of my writ application.
Yes.
My lord, last part. Reappearing in examination. The candidate need to pass individual theory, external course based on assignment and practical subject separately and in aggregate. If someone failed to clear that line, failed to clear any subject on its part can again reappear in 3 subsequent term end examination. So to complete the course with the payment of examination fees as per the NIOS. So there is an obligation from their part. If the petitioner failed to, my lord, cross the hurdle in 1 attempt, they should give in another two attempts. My lord, petitioner, my lord, then, my lord, kindly see the next page. Petitioner, my lord, first attempt, my lord, there is a mark sheet. My lord, next page. It is a continuing, but petitioner failed to complete in that course in first attempt. That's an entire, my lord, result cross just failed. Subsequently, my lord, it is the case of the petitioner, but the authorities did not given any further attempt to complete the course. Accordingly, now status of the petitioner is untrained candidate. Now, in this conspectus, my lord, some other candidate filed a writ application before this honorable court, that before the Honorable Justice Mantha. My lord, kindly see that order once. My lord, page 83, Suparna Chakraborty, Justice Mantha hold, since that they are under the obligation to given three attempts. Since that candidate has availed only 1 attempt, the authority should given another 2 attempts when next certificate course, when 6 months next certificate course they made an advertisement. This is the gist of the order. My lord, basis of that order, board carry forward that order. Board, my lord, board now, my lord, what steps has taken, page 87, my lord, strength of that order, board made an public notice that whoever similarly situated candidate be informed that we shall complete the train, that they may avail the training, they complete the training code, because so many candidates are there. Now they are an untrained candidate. At any point of time, they can remove, if they are depriving from incremental benefits, and they can remove from their service. This is the situation. Now, my lord, surprisingly, my lord, lastly, my lord, I am relying page 97 of writ application, 25th November 2025, my lord, NIOS, further, this is the, possibly, this is the second time they made advertisement after Justice Mantha's order, that they are started the 6-month breach course, but they have stated in their registration or open so and so, but they have stated in their advertisement who have completed, who have joined in the service after 28 as per ratio of Devesh Sharma. Devesh Sharma is, my lord, 20 prior to 2018, my lord, prior to 20 B.Ed is not a valid qualification, but 2018 NCT made a notification that B.Ed is also a valid training qualification. So we are not, my lord, since, my lord, we are not relying that notification, but at this situation, DLED candidate made an application challenge that NCT notification. Subsequently, Supreme Court struck down that notification and hold that DLED is the only training qualification. Now, basis of that, Devesh Sharma, they made an advertisement that whoever joined in service after 2018, they should be completed 6-month breach course. But we have joined prior to 2018. So when we tried to join this service, this course, we are deferring to enter this course. This is the position. So, my lord, at this stage now, petitioner also, there is no, my lord, there is no, petitioner has no alternate, my lord, petitioner has an alternative player too in this writ application. Petitioner also got admission in 2 years DLED course. If the authority give me assurance that petitioner would complete DLED without any disturbance, because my lord, NOC is required, since we are in service candidate. So 2 years, if this breach course is 6 months, and almost we have completed 6 months, but fail to qualify that examination. This is the position.
But DLED and this course can go parallelly.
No, either or, either or. But since we are
you have been admitted
in DLED courts,
so
but
what
course is not, course has not started yet. New year, new sessions, it would be started. But my lord, school NOC is required from the council, from the concerned DPSC. Now we are in service. Council may also objected that 2 years, how the candidate could be accommodated for 2 years, this situation. But we are facing some trouble. Either, my lord, we are praying that, my lord, NIOS give me an opportunity to complete that give me 2 attempts to complete the 6-month breach course after payment necessary requisite fees, or, my lord, board give me, my lord, some undertaking that we shall peacefully complete the DLED. Otherwise, my lord, we will face some difficulties in service, because, my lord, 32,000 can, my lord, in my lord, Priyanka Noshkor's case, my lord, recently Honorable Justice of Division Bench told that
why there will be a question of giving undertaking by the board on your assumption that a NOC will be required by the DPSC.
No.
If you face that problem, then this court is open. You can file a writ
subject to correction, my lord. Subject to correction. Previously, my lord, we also made an attempt, but concerned DPSC is not issued the NOC. Concerned DPSC not issued the NOC.
My lord, whatever he said is perfectly correct. There is no quarrel on the fact as well. Now, Lordship, the first notification which he shows, which starts at page 31 onward, this P4,
yes,
in 2017, that was for the candidate who was in service in 2016 and prior to that. Now, this new notification which he has just referred to is for the candidate who are joined the service 2018 and onward. But he joined the service in 2017. That is his admission in the writ petition. That is also, that fact is not disputed. So I cannot really accommodate him in a course, because I am doing this under instruction of 2 bodies. First body is my parent body, NCT and Ministry of Education, MOE, pursuant to the Supreme Court direction. So now I cannot make anything tailor-made. My problem is this. I have no objection. My infrastructure is there. If your lordship says and if the MOE says that yes, you do it, we will. But so far, as this notification is concerned, which he has not annexed, may I read and then hand over to your lordship? The teachers indicate at the point above, the course will only be meant for those primary teachers who have been appointed with BA degree in accordance to NCET notification dated such and such, and who were in service before the date of Supreme Court's judgment dated 28/11/2018. Appropriate mechanism to involve NCT and to ensure that candidates who are not covered under the ambit of the judgment of 2024 shall not avail of the course. The order of the competent authority. Lordship, he has not annexed
Yes,
this.
my lord, it is stated in the last notification also. দেখো আমি বলেই দিয়েছি তো। We have after Devesh Sharma. Was covering that after Devesh Sharma.
So, Lordship, the time period is here is 2018 to 2023. And Lordship, they are all admitted in the year 2017. Lordship will find that their environment is in page 5. I'm sorry, page 4. Para 4, page 4, para 4. And the relevant document of appointments are your lordship kindly takes, it starts from page 26 and onward. If your lordship takes anyone, these are all 2017 documents.
Yes, we have admitted.
And lordship, in the notification, which is published on 7/8/2025, we have categorically mentioned that the course will only be meant for those primary teachers who are appointed with BA in accordance with NEC notification dated 2018 and who were in service before the date. Means 28/6/2018 to 11/8/2023. May I hand over this soft copy, Lord?
But then is it so that the NIOS will coming up with a notification after this for 2016 or 17 were joined in service?
Notification 7th April.
How they are going to complete?
Lordship?
How they are going to complete their, they are also in service.
Yeah,
They have to
in
complete
service,
that.
Lordship. Now, there are two options. They can give NOC, they can do it for a full-time course. Or Lordship, if ministry directs me, ki, do this, we will do this. Now
My lord, I'm at this
Lordship, what I
situation-
say is, if he can add Ministry of Education as a party to it, they can come and they can take the responsibility under Supreme Court direction. It has been
Union of India is here. Union of India is. My lord, may I subject only, my lord, we are trying to here only resolve the issue. It's not that since the candidates are in trouble. So if your lordships observe it, entire thing which are my lord non-advent observed, my lord submitted, record that and direct the central government to take a sympathetic view upon the candidate. Let's see what will happen. If this will, I hope this problem will resolve.
What is your submission?
They are certainly last occasion I have told they are working under central government. That is why, my lord, I have.
But they claim 3 times this course, my lord. 3 times chance. Lordship kindly see page 88 of the circular of the National Council for Teacher Education. At page 89, my lord.
You keep it.
Well, that notification I also annexed.
Yes, yes, my lord. Great petition, my lord. Page 89, my lord. At page 89, my lord. Triple I. The teachers indicated at point it above may avail this one-time opportunity to complete the course as Honorable Supreme Court has directed that failure of any candidate to participate and complete the course within time frame as decided by the educational authorities will invalidate their appointment. Sufficient advertisement publicity shall be ensured by NCT in this regard. Qualifying the brief course will be strictly meant for teachers indicated in point II above, protect their existing employment only. So they can get the chance one time. As per circular dated 7th April 2025.
May I only some to that effect, may I reply? My learned senior friend submission is slightly different with my extreme friend submission. Because my lord, he is saying if the ministry is direct, we can conduct, we can provide two further attempts. That is,
we can't provide anything.
If central
An
government
instrument under central government, whatever central government does.
Yes,
I will
yes, yes.
abide
That
by.
is the. But this notification is, my lord, this notification is a current notification. Current notification, possibly their hand is tied because they come under the as per ratio of the Devesh Sharma's judgment, and possibly it is difficult. I should candidate, but we are here to resolve the issue. The candidate are suffering. Previously, they are undertaking three options. Three chance would be given. But they are admittedly they are given only one chance. If the central government take a sympathetic view and direct the NIOS to provide the candidate further two attempts, inter problem will be subject to resolve.
You are carrying the judgment of Honorable Supreme Court?
Devesh
Sharma, that I am not.
Devesh Sharma, I am gist of the order.
What is the language
Yes.
used? That they will be given one time, which is
No, my lord. Devesh Sharma, decision of Devesh Sharma is, my lord, B.Ed versus DLED. Previously, my lord, B.Ed is not a valid qualification as per NCT rule. 2018 NCT incorporated new rule and said the, my lord, if subject to correction, if and B.Ed also a valid training qualification, then DLED candidate filed challenging that notification and filed a writ application before the Honorable Rajasthan High Court. Rajasthan High Court, my lord, goes subsequently that order dragged to the Honorable Supreme Court. Honorable Supreme Court hold no. Only DLED is the valid training policy, and 2018 notification has been struck down. This is the situation. And my lord, this notification possibly come that they are saying that whoever admitted after, but even Devesh Sharma subsequent clarification, it has been said this order is not applicable retrospectively, rather it is applicable in prospectively. They are saying whoever joined their service 2018 with B.Ed qualification, new notification, they would be facilitated. Just like previous application.
But is it so that in Devesh Sharma this one time is to be given?
No. Devesh Sharma is not. That is not
see,
different.
NIOS has floated a notification wherein it says he has shown that 3 times will be given for.
Devesh Sharma is not dealing.
NCT says that Devesh Sharma's
Lordship, the
judgment.
problem was with the conflict here is the Supreme Court, there was a guideline and the time frame. Now, since the course was floated late, course was carried on in a different way because all on a sudden it had to be implemented. So, Lordship, then the time gap was not there. Now, moment time gap was not there, it is over, and they could not qualify it. Now, the second notification, and second notification is for the next slab. But now he has, if at all, if he says that the getting 3 chances are my right, so then that is a separate cause of action. And getting into a next batch will be another consideration. Getting into the next batch I cannot allow because my clarification clearly says appointment has to be after 2018, June 2018 rather. So he is prior to that. So he cannot come under this new notification. So my submission is only restricted to the extent that this new notification he cannot come. Now if we go back to the earlier thing, what is his right? Now Lordship kindly see, he has earlier the writ petitions which are filed, if your Lordship kindly come to the High Court orders at a page 80 to 83.
83. Suparna Chakra.
There are 2 orders you have given. One is Ranjan. I think Ranjan Mukherjee will be more important for you. If you kindly come to page 81 and 82, this judgment might come to his rescue. This can be. Now kindly come to paragraph 9.
Page 82.
So page 82, paragraph 9 will come to his rescue. Now he has to enforce this.
Yes.
I'm sorry. I cannot take his brief, but I think he has to enforce this paragraph 9
Yes,
against the Union of India. So he has to do this, that since the court has taken this view, now this has to. So board and other party, I might be a party, but other has to be, he has to enforce this right. And if we vis-a-vis see into superness, story mamla korchi baba. If we look into page 85, para 8. Since the NIA itself permit such and such, the petitioner are entitled to reattempt the said breach course examination of this, which was held in 2019 in terms of the program guide. Petitioner are entitled to reappear in the exam 3 subsequent even upon this. In these circumstances, direct the NIS to participate for the next available upon payment of this. So these are two his substantive right he acquires from the previous litigation. Now he has to pursue these two substantive line against Ministry of Education and NCTE, National Council for Technical Education.
Let the matter be relegated to the central government to take a suitable decision. That much. That can be. Central government also, central government also agree.
Central government will do anything, cannot. It will be better if your lordship educated to the
NCT, no, NIOS.
Direction of the NCT, NIS is conducting this course. Subject to correction.
No, my lord, subject to correction, my learned friend, NCT is NIOS is now separated from NCT. NCT is NIOS.
Separate body.
Yes, central government.
On the direction of the NCT, NIOS conducting this
NCT current. NCT is father.
Yes.
I am a grandchild. He is father.
Let us central government. Delegate the issue to the central government.
Come from the grandfather.
Ministry of Education.
Ministry of Education.
Now it is MOE. So grandfather is MOE.
Yes.
So MOE has to say, and
central
then it
government
will
might
percolate.
has no objection, my lord. They are expresses. But some candidates maybe, my lord, situation may improve some.
Affidavit of service আগে দিনই দিয়েছে, ঠিক আছে. By the present writ petition, the petitioner seeks direction upon the respondent authorities to allow the petitioners in 6 months breach course, which has been notified on 25th November 2025. And para. Admittedly, the petitioners are working as assistant teachers in primary schools under the state. They have passed B.Ed course. The B.Ed qualification has been declared as ineligible. By the order of Honorable Supreme Court passed in Devesh Sharma versus Union of India and others. The Union of India, Devesh Sharma was Union of India. Civil level आगे रहते पेज जावे.
May I take lordship's permission, my lord? For code number 33 is calling me. May I take?
Yes. Thank you. The petitioners previously appeared in which examination this is?
PDPET.
This is appeared in page 31.
Yes, page 30.
Appeared in PDPET. ফুল ফর্মটা দিয়ে দেবো না. Professional Development Program for Elementary Teachers within bracket PDPET 6 months the 6 months breach course. In which year they appeared?
Well, in 2017. That time
2017. However, they failed to succeed in the said examination. As per the previous notification, as per the program guide of the PD PATE course, the unsuccessful candidate can reappear or the candidates are given unsuccessful. The candidates are given three opportunities. Three opportunities.
Page 72.
After 2017, no such advertisement has been made for conducting the 6 months breach course. Recently, the NIOS, who wrote it there? National Institute of Open Schooling, NIOS, has made an advertisement on 25th November 2025 notifying for 6 months breach course, where those primary teachers who had been appointed with B.Ed degree in accordance with NCT's notification dated 28 June 2018 and who were in service prior to Honorable Supreme Court's judgment in Devesh Sharma Supra delivered on 11th August 2023 were allowed to take admission in such course. The petitioners who have joined service in the year 2017 is unable to take admission with such notification dated 25th November 2025. Mr. Swenso, learned advocate, appearing for the petitioner, submits that the petitioners who are in service since 2017 needs to complete the training course, either 6 months breach course or 2-year DLED course in order to continue in the service. The petitioners were allowed to appear in the allowed to take admission in the 6 months breach course earlier, PDPAT, that is PDPAT. Since the notification dated 25th November 2025 does not cater to the in-service teachers prior to 2018, the petitioners are unable to take admission in the 6 months breach course. He seeks for necessary direction upon the central government to take appropriate steps in this regard so that the petitioners are able to complete the 6 months breach course. Mr. Shiv Shankar Banerjee, learned advocate appearing for NIOS, submits that the notification is in respect of teachers who were appointed with B.Ed degree in accordance with NCT notification dated 28 June 2018 and were in service when the prior to the judgment of the Honorable Supreme Court in Devesh Sharma Supra. Therefore, the petitioners who were appointed in 2017 cannot be accommodated in terms of the notification dated 25th November 2025. However, he indicates that necessary direction be issued to the Ministry of Education to take a decision on this issue. Mr. So and so learned advocate appearing for the Union of India submits that the opportunity is given to the candidates once. As such, the petitioners have availed of the opportunity and are not and should not be allowed to take admission once again to complete the 6 months certificate course bridge in primary teacher education. However, he also submits that the decision may be relegated to the central government in this regard. In similarly circumstanced candidates, this court has passed orders in WPA 14503 of 2023 and WPA 19588 of 2022 with the following directions. 8 and 9, 85. Accordingly, the central government, particularly Ministry of Education, is directed to take a decision with regard to in-service candidates prior to 2018 for completion of the training courses to be initiated by the appropriate authority. With the aforesaid direction.
And my lord, only one observation. If my lord, since my lord, they should take a decision and my lord render their view to the NIUS. My lord, only one observation, but otherwise if they take decision, my lord, it's consequential state.
And communicate their decision to the appropriate authority,
NIUS.
Namely the NIUS, as well as NCTE.
Yes.
With the aforesaid direction, recipients and disposed of. Yes, okay. Water matter din to. এই সাপ্লিমেন্টারি করেছেন তো?
এক মিনিটের ম্যাটার।
12টার ম্যাটার
যা বলবে তাই হবে। Application for participation in the selection process for primary school teachers. The Board of Primary Education had given the notification page 16, 19th of November 2025. Last date was fixed for filing application on 9th of December 2025.
But yes, Mr. Vishwas.
My lord, I have taken instruction, my lord. The only predicament, my lord, what is troubling me, my lord, that is, my lord, this writ petition was affirmed, my lord, 16th December. My lord, the last date was 9th. My lord, this is the, my lord, the predicament. My lord, if we allow it, my lord, then, my lord, tomorrow, my lord, the number of, my lord, petition will be filed before your lordship, my lord.
Then
this is the only predicament. Otherwise, my lord, we have no objection because, my lord, he has also, my lord, waited till, my lord, 8th to deposit the fees. It was started in November. He waited, he or she waited till 8th. This is the only predicament. I will not in the stand up on the stand.
Very fair submission on this part.
This is the predicament.
Page 17, if your lordship pays a look, my application that was submitted on 7th of November. Lordship will get it on page 17 and 7th of December. 9th of December was the last day. At the bottom, my lord, page 18, my lord, the date will be reflected. 7th December. And server,
and if your lordship direct us,
resulted in not transferring the money in their favor. Only online, my lord, the amount, nothing further has developed in the meantime. My lord, no examination.
if your
has
lordship
been
direct us, subject to your lordship, if your lordship direct us, will take, but it will not be a precedent. That your lordship can record.
No, but if she has attempted on 7th December, only because of his server, she could not deposit the payment.
Only rupees 500, my lord, I am spending so much of money to come to court, my lord. I have made an attempt, the village passes, my lord, even for myself, my lord. I have also failed in, my lord, depositing the money in time, my lord, because of the server problem in many cases. Air tickets, other difficulties. I have stated in paragraph 5, my lord, in details to what happened. My lord. Only for my participation, no appointment is ensured in myself.
Affidavit service filed on behalf of the petition is taken on record. The petitioner seeks direction by the present writ petition. The petitioner seeks direction upon the respondent authorities, particularly the respondent number such and such, with primary education, to allow the petitioner to deposit the application fee
Board of Primary Education.
to offline. Offline can be accepted?
Yes.
Offline it is very difficult. Offline means
By any mode which is acceptable to the board.
Any mode, my lord, online is now no more available.
The server, it is not, the server is closed.
Unless your lordship direct for offline deposit, my lord, it is difficult for us to do.
কি বললাম? To offline mode.
Your lordship, instead of offline or online, may subject to correction. Your lordship, direct the secretary to accept the fees. Kindly do not mention online or offline. And the ask the
Make arrangements for acceptance of the fees of the petition.
Yes, and also your lordship observe the petitioner should contact immediately with the official or the secretary of the board by today or
period of 1 week.
By tomorrow.
By tomorrow.
By tomorrow.
The petitioner
answer offline
that she intends to participate in the ongoing recruitment process initiated by the board in terms of its notification dated 25th September 2025, read with notification dated 19th November 2025. The petitioner attempted to submit her form on 7th December 2025. Bracket করুন, the last date being 9th December 2025. However, the petitioner was unable to successfully submit her form since the server did not allow for deposit of the fees. The petitioner seeks appropriate direction for deposit of the application fee. And allow the application of the petitioners to be submitted before the appropriate authority.
Along with the fees.
Along with the fees. Mr. Bhattacharya, learned advocate appearing for the petitioner submits that the petitioner tried to deposit such fees, but due to server glitch, the same could not be deposited, which has resulted in the inability of the petitioner to participate in the ongoing recruitment process. He seeks for appropriate direction so that the fees application along with the fees may be deposited before the board. Mr. Ratul Biswas, learned advocate appearing for the board, submits that if the court decides in favor of the petitioner, that should not be a precedent, since the writ petition has been filed after the last date of the closure of the application. Considering circumstances, it is found that from Annexure P4 of the writ petition that the petitioner made application on 7th December 2025. The petitioner has also made a representation on 12th December 2025 contending of the facts as stated in the writ petition and the inability to deposit the application fees. Considering the entire circumstances, the secretary,
respondent number 3.
Secretary, responsibility secretary, West Bengal Board of Primary Education, is directed to make arrangements for submission of the form of the petitioner along with deposit of application fee if it is made by tomorrow. With the aforesaid direction, the writ petition is disposed of. It is made clear that this order is restricted to the petitioners and will not be a precedent in case of other applicants.
On one line, the petitioner will contact the board by tomorrow.
Secretary of the board by tomorrow.
The petition is directed to contact the secretary of the board by tomorrow.
During office hours.
During office hours, obviously.
Grateful.
Your Lordship, we have
Server copy may be made available to us in course of today.
It will be. Item
number
Your Lordship, we have a 12:30 fixed matter.
That 12:30 matter, my lord, may call.
Item number 6 will be disposed of immediately.
6.
Fix it.
12:30 matter, if my lord calls. কালো হবে
Item number 6, my lord, on behalf of the petitioner. I am paying for after this. He has not come today.
Let it be go out of list, my lord. My lord, because of my lord something, my lord, he is not moving this writ petition.
Go out, not this secret.
Let it be in the list.
After vacation.
It will appear after the vacation.
Yes.
If he is not interested to move, then we'll see.
Yes. আমাদের কত নম্বর? That 609 was fixed.
09.
Yes.
না না কোশ্চেন দাও রিটেন নোটটা দিলাম These are supplementary. This is our scan application.
আপনি তো ওদের দল এভাবে দাঁড়িয়ে কি করবো
Opposition, আমাদের দেখলেন সার্ভিসটা দিয়ে দেবো জমা
প্যানটা কোথায়
opposition আমাদের সব supplementary connection.
Not kindly take.
Prior to me, Lord, moving the matter, I am appearing on behalf of the writ petitioner. There is a, my lord, supplementary affidavit. My friend will, my lord, argue. There is the exchange of affidavit. I don't know as to why there is so urgency that the matter has been released because, my lord, the matter has been mentioned before the honorable bench. Having determination, agitated the matter, the urgency. The concerned bench did not consider it appropriate to get the matter listed. On that day, when the matter has been listed for release, I went over there, requested the Honorable Court to take up the matter. But, my lord, he expressed his view as to why the matter would not be taken, because on the previous day, matter has been agitated, saying that there is extreme urgency of the matter. Court did not find it appropriate to take up the matter, and subsequently he released the matter. Then matter has been assigned. Then, my lord, tomorrow is the, my lord, the date. Tomorrow is the, my lord, the date of our vacation. Prior to that, the matter has been posted that there is a extreme urgency in the matter. I did not find, my lord, what is the extreme urgency. Although, my lord, the affidavit has already been exchanged on a supplementary affidavit. Let us argue the case. Thereafter, I will argue suppose the merit is the case.
Lord,
But I think that, my lord, within half an hour, it would not be completed.
Now I believe this is a very nice practice that all of us we are adopting. Before the petitioner starts or applicant starts, you come, you say all in merit and say, I don't say, let him submit. Lord, I say, what is the issue? Lord, kindly take 3 documents of your lordship's record. One application, can 1, a supplementary affidavit.
First of all, tell me whether this can be posted after the vacation.
It cannot be. If it is posted after the vacation, it will become
satisfy on that score.
Yes.
Then because affidavits have been exchanged, we are getting to the merits of the application.
Great.
If it is possible, then we'll fix it a date after the vacation.
Absolutely.
Great.
My lord, one thing, my lord, I am for the state, my lord.
বলবে না ম্যাডাম ওরে বাবা Lord, what is the urgency? Lord, I just give you lordship 2 minutes facts to come to the urgency. My lord need not look into the pages for the present. Let me tell you, lordship, why I am today and I am traveling one day before the vacation.
Yes.
Lord, a candidate which Mr. Dotto is representing, he was allotted a seat in the 3rd round of counseling in a private medical college in state quota. According to the MCC circular, West Bengal Medical Counseling Committee, who conducts the counseling, he was supposed to visit the college between 6th of November to 8th of November with a bond in the nature of an indemnity. What is the bond? The course, Lord, there are 9 semesters in the course. As per the law, I mean rule system, 2 semesters fees we can take in advance. Rest 7 semester fees, he will have to produce post-dated checks and a bond that ensuring that he will make payments. That is a system norm fixed by the government of West Bengal Medical Counseling Committee. Now, he on 11th of November filed a writ petition before Justice Basu, saying that he went to the college. College was insisting for a bank guarantee, so he could not get admitted. Matter was taken up on 12th, showing urgency. 12th, when the matter was moved by him, Mr. Dotto was not there. Someone else appeared. The submission was that the college was insisting for a bank guarantee. I had a bond, so I could not produce it. College did not accept, so kindly allow me admission. We submitted that college has never insisted for a bank guarantee. You did not come to take admission. He produced a bond before the court on the time of hearing. During the course of hearing, he produced a bond.
The bond acceptance is within the statutory rules.
Within the statutory rules. That I will show. He produced a bond. During the course of hearing, Justice Basu asked me that you inquire from your client whether this is all right or not. We scanned and sent to the college. College says within 5 minutes, matter was passed over 5 minutes. College says yes, format wise, it seems to be okay. We informed, the court passed an order. But in the evening, we got an information from a well-wisher who looked into the document and found that there might be some discrepancy in the bond. But I sent my junior to the office of the CJA Malipur to check the veracity. She filed an application before the CJA Malipur. The CJA Malipur answers that the bond is fake, the seal is fake, signature is fake, the bond was never executed by their office. We immediately rushed to the court, saying that please recall your order because the order has been obtained by playing fraud. That is the application, can 1. Now, Justice Basu on 14th or 17th stayed his lordship's first order. 17th of November stayed his lordship's 12th November order, which allowed admission. But when the matter was taken up on 20th November, that was the last day on the in medical counseling, there are several rounds of counseling. First, second, third, then a stray round comes. Now, what is going on now is a special stray round as per the order of the Supreme Court and order of the central government. So 20th was the last day for the stay round. He came to court. He said, my lord, today is the last day. Allow me to produce another bond so that I could get admitted. Now, my lord, Justice Basu directed him that if you could go within the time scheduled today with a fresh bond, which is in proper format, you will be given admission. He was supposed to go to a college in Durgapur. He did not go. He went to the admission center at the medical college, which was not for, which was only for online admission. Be that as it may, he came to us. He produced a bond. We have given him a provisional admission, subject to the point that if the format is not correct, we will recall the admission. He went there. He took provisional admission. And I'm missing one thing. Justice Basu, after coming to know of this forgery, directed us to file an FIR, directed the DIG CID to investigate. So we immediately filed the FIR. DIG CID is investigating. State will be not able to inform your lordship what is the outcome of the investigation. Now, first order that you would be admitted 12th November, 17th November, that it is stayed, 20th November. Very well, if the format permits, you will be admitted. We challenged the order of the 20th November before the division bench. Since we have taken him admission, division bench kept all points open and said, you go back to the court, inform the court that this admission also he has taken in a format which is not as per the court's order or the format which is given in the website. The court will decide. We filed a supplementary affidavit before Justice Basu. They were directed to file objection. They filed an objection against the supplementary. We used a reply to the supplementary. Now, can is pending before my lord. Now, what is the urgency? Not the the central government has published a notification. Published a notification saying that kindly have a look at it. And this is kindly then take this as well. Kindly have the notice. Copy. Kindly have a look at this 17th December order. Undergraduate Counseling 2025. Kindly see the schedule. My lord will get the schedule that I have handed over yesterday. This is the notification by which the dates are extended. Kindly have a look at the schedule. The schedule is, state counseling schedule is 20th December to 25th December. Now today, we are praying that his admission should be cancelled. Kindly appreciate the urgency. Today, if my lord suppose decides in my favor, his admission is cancelled. My lord will be directing the MCC to show this seat as a vacant seat, because as per the norms of the MCC, if a student doesn't take admission, the seat will be shown as vacant. Some other eligible candidate will be able to take that seat in the ongoing counseling. If the matter is decided in January in my favor, he will be losing his seat, but the seat will go vacant. So if my lord decides this now, considering that the counseling has been reopened until 25th, the counseling will go on. He is not going to suffer any prejudice. If in January my lord decides in my favor, he will be losing the seat. If in February my lord decides in my favor, he will be losing the seat. But if my lord decides now, considering this situation, then the seat would not go vacant if I succeed at all. I might lose. He will be continuing his studies.
How?
Because he has taken admission provisionally. If I lose, my lord, if I lose, he has been given provisional admission. If I lose,
provisional admission is by the order of the court.
By the order of the court. By the order of the court. And the court, may I show that order to your lordships now? Kindly not take the application and the supplementary affidavit. Now kindly first take the application can 1. Can 1 take Joseph bar kore deben.
First tell me, the provisional admission has been granted by which order?
Yes, I'm sure that is
that order is required.
Not kindly take not first 12 November order. Order annex করা আছে। First take the 12 November order. এখান থেকে বাকি order তো বার। First take the 12 November order, the first order. Lord, kindly see the petition. My lord, is the 12 November order, Lord. The petitioner, being a successful candidate in the NEET UG 2025, had participated in the counseling conducted in the medical counseling committee. The respondent number 3 herein for admission in the medical courses in West Bengal in the 3rd round of counseling, the petitioner was allotted so-and-so medical college. Respondent number 8 herein under unreserved category against the state quota, but he was denied admission Purportedly for his failure to furnish bank guarantee, Mr. So-and-so, learned advocate of the petitioner, submits that the petitioner to get admission in the allotted college is obliged to furnish a bond to the nature of bank guarantee. Mr. Chakraborty, learned counsel for the respondent number 8, submits that the petitioner is required to furnish a bond to be executed before the first class magistrate, which he did not do. Mr. Mukherjee produces a copy of the bond executed by the petitioner before the first class judicial magistrate Alipur, District Judge 24 Pargana, and submits that the bond would be submitted before the college. Mr. Chakraborty, on verification and on instruction, submits the said bond would suffice the purpose. Petitioner number 3 is directed to approach the respondent number 3 college and 3 and 8 on original bond to complete the admission process. Respondent number 8, upon production of the said original bond and upon compliance of the other formalities, shall admit the petitioner, and thereafter the respondent shall regularize. So before he could be admitted, or পরের order গুলো দাও, we have 17 তারিখের অর্ডারটা দাও না, কোথায় 17 তারিখের অর্ডারটা? Give me the 17th order. Then Miller, the next order comes. Kindly look at the order dated 17th November. 17th এর আগের অর্ডারটা কবে? 17th. Kindly take the 17th November order, second order. Passed on the, my lord, is it 17th November, Miller?
Yes.
Passed on the can 1. 17th November. My lord, see that can 1. 17th November order.
Yes.
This is an application filed by so-and-so college, herein praying for recalling of the order dated 12 November 2025, passed in the connected writ. The petitioner was successful in NETG in the round 3. The petitioner in the connected writ petition had alleged that college is illegally inside bank guarantee. The writ petition disposed of. The order is quoted. Kindly come to the second page. Mr. Chakraborty submits that the college authority on production of the original bond had detected some interpolations and in it. As such, it was not accepted. However, on the basis of the available photocopy of the college authority took steps to ascertain veracity of the said bond, and in furtherance thereof, the learned advocate of the college, Ms. Rupsa Simani, by a letter dated November 13, had prayed before the chief judge, learned chief judicial magistrate so-and-so, before whom the oath was originally administered on November 6 in relation to the execution of the bond. In reply to the said letter, head clerk of the said court, by letter dated November 14, has informed the said learned advocate that the affidavit bearing number so-and-so in favor of Risiraj Das was not issued by the said office. Mr. Chakraborty further submits that the petitioner has practiced fraud upon the court by producing forged document. As such, DIG CID may be directed to investigate. Mr. Chatterjee, learned senior advocate for the petitioner, submits that the petitioner is not shying away from the investigation, but the allegation is yet to be proved. At this stage, the college should not put in the career of the bright student like a petitioner at stake. Then, the hard learned counsel, in view of the letter bearing number dated so-and-so, head clerk of the office of the learned chief judicial magistrate, first class Alipur, a prima facie doubt regarding the genuinity of the bond executed by the petitioner has been created. Therefore, the direction of the court upon the West Bengal Medical Counseling Committee and 3 and 8, respectively, to complete the admission process of petitioner upon production of said bond shall remain stayed until further order. The respondent number 8 is directed to division bench order, directed to lodge a formal complaint with the jurisdictional police station, that is Bhawanipur police station, regarding the alleged forgery executed. Original bond produced by Mr. Chatterjee be handed over to Mr. Chakraborty for keeping the same in the custody of the respondent number 8 college, so long it is not required by the police authority for photocopy. Matter was listed on 20th November. Now, my lord, the next day you also will find the order that the police station name is changed from Bhawanipur to Alipur. My lord has seen that, not? Then kindly take the 20th November order. My lord, is that 20th November, my lord?
Yes.
Yes. The petitioner is a successful candidate of NETUG in the third round of counseling conducted by the West Bengal Medical Counseling Committee. Respondent number 3 hearing. Lord, this is the reiteration. My lord may kindly take, Lord, internal page 3. Internal page 3 of the order. Had the learned counsel, Matter has got that. Had the learned counsel for the parties produce the materials on record. Today is the last date of admission. The bond produced by the petitioner to get admission prima facie appears to be forged document. Now, 20th November, internal page 3.
Yes.
I'm sorry, my lord.
Yes, yes, continue.
Yes. Today is the last date of admission. The bond produced by the petitioner to get admission prima facie appears to be a forged document. However, the involvement of the petitioner in the act of forgery is yet to be established. Therefore, it will be inequitable to deny his admission at this stage. The respondent number 3 and 8 are directed to complete the, mark this portion, complete the provisional admission of the petitioner in bold, subject to production of fresh bond within the scheduled time today, and subject to prima facie satisfaction of the respondent number 8 regarding the veracity and format of the said bond. The admission of the petitioner is subject to final outcome of the pending criminal proceeding. In the event the petitioner is found guilty in the said criminal case, his candidature seat allotment shall be cancelled with immediate effect, and in such event the petitioner will be liable to compensate the college. The petitioner, if fails to produce the fresh bond today within the stipulated time, the direction to block the seat allotted to the petitioner shall stand vacated, and the respondent number 3 shall be at liberty to put the seat in the next round of counseling, treating it to be vacant one. So, my lord, I'm stressing on two paragraphs. One, the fourth paragraph, starting that the bond has to be prima facie in terms of the format, and if he fails, it will be shown as a vacant seat. The DIG CID is required to take over the investigation of Alipur PS case number so and file progress report. Matter kept on 27 November. But we challenge this order before the division bench. This is the division bench's order. Copy nahi. But that is annexed with our supplementary affidavit. The division bench's order.
Page number?
Got page number 30.
Yes.
Lord, kindly come to page 31. Second paragraph. Mr. Call and senior advocate appearing for the appellant submits that the bond which was produced by the writ petitioner at the time of hearing of the writ petition on 12 November was a forged document, as would be explicit from the document annexed at page 102 to 103 of the stay application. Having produced such forged document, the writ petitioner could not have claimed any equity, and the learned judge erred in law in exercising discretion in favor of the petitioner. Then, my lord may take over page 32. In reply, Mr. Kaur submits that the bond which was furnished by the writ petitioner pursuant to the order date 20th November also was not in form and in consonance with the directions contained in the order. Then kindly come to the... Oh, I'm so sorry, my lord. I'm so sorry.
Yes. Yes.
Then kindly take the next paragraph. According to the query, Mr. Maiti, learned advocate appearing for the university, submits the counseling process has already been completed. So the situation was otherwise then. We have heard the learned advocate appearing for the respective parties and consider the materials on record. By the impugned order, learned single judge directed the admission of the writ petitioner subject to final outcome of the criminal proceedings. Pursuant to such direction, the writ petitioner produced a face bond before the appellant, and he was granted provisional admission. It thus appears that the order has been acted upon. Furthermore, the record would reveal that the writ petition has been made returnable on 27 November as to be mentioned. In the said conspectus, we are not inclined to interfere with the order impugned, and accordingly, the appeal along with the application dismissed. It is, however, made clear that the dismissal of the appeal shall not prevent the appellant to advance the argument before the single judge on merit and on the issues urged before us. So the issues that was urged is forged document, and the 20th November order has also not been complied with. Now I'll show how it is not complied with. But kindly take the supplementary affidavit. But kindly take the document of provisional admission at page 11 of the supplementary affidavit. Lord, 20th November, the court directed him that you go with a face bond. If that is in proper format, they will give you admission. Kindly see the provisional admission that we have given to him.
Page number?
Page number 11 of the supplementary affidavit. Malaras kindly got that. Now kindly see after the boxes declaration. Malaras got the declaration?
Yes.
It is on 20th only. I clearly understand and agree and acknowledge that my present admission is purely provisional as per the directions of the Honorable Court in WP number so white order date 20th November. This is subject to verification of the submitted bond and its component as well as further direction from the Honorable High Court at Calcutta in the above mentioned matter. So knowingly he has given this declaration subject to verification of the bond. Then I'll kindly take the bond that he had. Kindly look at the format of the bond that is available with us. But kindly come to page 27. The court has said it has to be in the format. Kindly come to page 27. What is that page 27, Lord? Lord, kindly see. Lord, after 1, 2, 3, 4, 5, 6, 7, 8. After 10 lines of the first paragraph, page 27. 10 lines of the first paragraph, kindly see. Third blank. I, the obligor student, bind myself and my heirs, executors, administrators, legal representatives, and we. My Lord, your Lordship is looking at the bond submitted by him.
No, this is format
No,
of the board.
Page 27.
Yes.
Yes. But kindly have a look at that there were two, what I'm trying to show that there are two guarantors. We, one blank and two, both residing here and after as to the guarantors, which expression shall unless excluded or repugnant to the context so and so. Format demanded signature of two guarantors. Now your Lordship is having the bond in your Lordship's left hand. Kindly take the bond submitted by him. Page 12. Lord, kindly take page 14. Take page 14.
Yes.
Now kindly see page 14. After 19 lakhs 18,000 written, I, the obliger student, bind myself and heirs, executor, administrator, legal representative, and we, Sri Anup Das and Srimati Tumpa Das, residing at so and so, referred to as the guarantor, which expression, unless excluded or repugnant to the subject context, shall be deemed to mean and include so and so. Now kindly now come to page number 18. Only one guarantor signed. Page number 18. অবজেকশনটা বার কর আমার এটা কোনো দরকার নেই Look, two components I'm trying to place before your Lordship is one is that, then I'll take back your Lordship's 2 minute the initial bond issue, whether that was at all required statutorily. So 20th November, Justice Basu was extremely clear that it has to be in proper format. Provisional admission shall be granted. My Lord need not trouble yourself, Lord. I'll just, for your Lordship's kind recollection, respondent number 3 and 8 directed to complete the provisional admission of the petitioner subject to production of face bond within the time schedule, subject to primary satisfaction of the respondent number 8 regarding the veracity and format of the said bond. So the bond submitted by him is not in format. So his right to get provisionally admitted goes. This is apart from that he secured the first order of admission by playing fraud on court. Now I'll come to that. Now kindly take the writ petition once. Just to show one page, my Lord, to your Lordships. Document, bond schedule, yes. Now kindly take page 48 of the writ petition. Plot 48 is the tentative revised schedule for counseling West Bengal NEET UG 25 state quota, private management quota. Now this is the counseling. Or kindly turn the page, come to serial number 8. What is the serial number 8, Lord? The reporting and admission allotted to the candidates to the allotted institute. For all private medical colleges, the admission process will be in different government medical colleges in Kolkata. Related to notice has been published in the website of All India Medical Dental Council with requisite original, kindly mark this, with requisite original document, college requisite fee and bond. Once successfully re-verified, they can get admitted and allotted seat. So the bond is a necessary requirement and it was to be produced between, kindly see on the right hand side date, 6 to 8 November. Now, What was his case in the writ petition? Why I say forgery from day one, not only the student, his parents. Kindly see paragraph 11 of the writ petition. Page 8, paragraph 11.
Yes.
Yes. What he says, on 6th of November 2025, the petitioner through his father, not Kali, mark this, petitioner through his father immediately approached the State Bank of India, Durgapur. So I am the student. I sent my father to State Bank of India, Durgapur on 6th of November to prepare a demand draft on 6th of November in favor of the respondent number 8 college, and had also issued the 3 post-dated checks on 1st September so and so in favor of the respondent number 8 college as per the fee structure. Photocopy of the fee structure is annexed. He has also annexed the demand draft. Malad will get that at not page 55.
Yes.
So his case is, kindly they have a look at, this is the demand draft prepared in State Bank of India, Durgapur on 6th of November. At the top, you also will get the date. Now, my lord, so his case was that his father was there on 6th of November in Durgapur to, my lord, prepare the draft. That nobody can dispute today. That is his case. And he actually prepared the draft in Durgapur. He actually prepared the draft in Durgapur. Take the supplementary affidavit now. Can you take the CAN application now? Look at the forged document that he produced in court. Annexure P2. Lord, the petitioner resides in Baharampur. The college is in Durgapur. The bond is prepared in Alipur.
Supplementary.
Can one. There is only one can, Lord.
Page number?
Lord, page number 18. Lord, this is the document which was handed over in court before Justice Basu. Lord, kindly have a look at this. Page 18. My lord, is at page 18. Lord, kindly see first class Chief Judicial Magistrate Alipur. There is a stamp of the Chief Judicial Magistrate Alipur at the first page.
Yes.
Then kindly, Lord, come to page 19. His address is there, the Rishi Raj Das, Baharampur. Page 19. In the back, Lord, reverse page of the bond. Lord, kindly come to page 22 of that particular bond. Lord, kindly sees here in this bond, Rishi Raj is signing, Tumpa Das is signing, Anup Das is signing. Admittedly, Anup Das, father of Rishi Raj, was on that date in Durgapur. Then he put his signature knowing it's a fake document. Lord, I come to court, I take the court for a ride, I produce a forged document. When I'm caught, I say that, my lord, let it be investigated. Let me study. Lord, we are not against him. We have to run our institution. Why would a student having this sort of a checkered character, who has taken the court for a ride and got an order from the court by producing forged, Lord, on 12th of November, he was not eligible to get an admission. Why? Because the time was from 6 to 8. He was directed to be reported on 6 to 8. If he doesn't report, what will happen? I'll show your lordship. The seat will be shown vacant as per the MCC guideline. It is annexed to the writ petition. He only annexed. He knew it. So that is why he prepared a forged document came to court on 12th, said that, look, my lord, I had this. The college had not accepted it. Now he says that somebody from Alipur court has given me this document. His father was not available. He knew it. Lord, from day one, from the moment he came to court, he engineered this fraud. Kindly take the next page, page 23 of the CAN, or rather 24, the CAN application. Lord, 23, Miss Simani made an application to the magistrate. Kindly see the magistrate, what the magistrate says. Subject to verification of the affidavit number so and so with reference to the above, I am to inform that the affidavit bearing number so and so, dated so and so, in favor of DC Rajaj was not issued from this office. Lord, if my lord comes back to page 22 one more time, the signature, the seal, the number, the name of the lawyer, everything is forged. We are told that the lawyer has died 5 years back. I don't have the document, my lord, I cannot show. The lawyer is also dead. The seal is forged, the signature is forged, the number is forged. So Rishi Raj knew it, that he did not go to the office of the magistrate. Rishi Raj's father knew it, that he was in Durgapur. Then why did he put his signature here? This shows that from day one, this petitioner was planning, that he knew, because why this was necessary.
যদি রিপোর্ট না করে ব্যাকিং যাবে, সিট না যদি করতে পারে নন এলিজিবল সেটার দরকার।
Yes.
Why this was necessary for him? A question may come. Why would I do it when I got a seat? Page 35 of the writ petition is the answer. Page 35 of the writ petition is the answer. Why he engineered this fraud? But I'm sorry, I am traveling a lot with here and there, but this is how the pages are arranged. Page 34 kindly takes first. Lord, this is a part of the information bulletin published by WBMCC. Page 34, last round 3 counseling. My lord gets that at page 34, last paragraph. So round 3 starts, then kindly turn the page. Round 3 starts here, turn the page, kindly come to the third last bullet point of page 35. The candidate who remain admitted in round 3 counseling are not allowed to further participation in the further round of counseling. They are not allowed to surrender their seat. Then thereafter, the candidate who remain not reported in round 3 after allotment are not allowed any further in the counseling process, as they are out of the counseling process. So, as per page 49 of the writ petition, he was supposed to come within 6th and 8th of November. He did not come. So after 8th of November, he became ineligible because he was so non-reported. He came to court, created a bond, because he could not have gone on 9th or 10th before the magistrate and said that you make a bond of 6th. Created a fake bond, made out a case that I had the bond, college did not allow me. Had it been a case that he did not have the bond, he would have lost the scope to get admitted as per page 49 and then 35.
Yes, who is for MCC?
No, Miller, I am appearing for the writ petition. Only few things are required to be clarified.
No, just I want to clarify. Since the college says that if it is not completed within, just a minute, within suppose 25th, then the other candidate who is in the waiting, he cannot opt for that vacant seat. What is the way out of this? Who will answer?
The admission is already provisionally made.
Yes.
So today was the choice locking. Seat matrix has already been published. Today was the last date for choice locking for 167 seats. For the remaining 167 seats. Cancelled, my lord. we cannot put this seat forward in the seat matrix. If there is another round as per the All India schedule, that is scheduled from 1st January to
The last round will be
5th of
for the
January.
state of West Bengal will be the 1st of January to 3rd of January.
Yes, round 5.
So, if your lordship is cancelling the seats, that seat will be, uploaded, carry forward in the next.
Yes.
So how many rounds will be there? Fifth round is the last one.
5th round from 1st of January, my lord, in the seat.
The 5th round going on. If the January round happens, that will be the 6th round.
Sixth.
Generally, there are.
So what happens after, since in the schedule I find that 10th January is the last date for joining.
My
Now suppose after joining one or two candidates, they leave the college
my lord, in
to join in some other college.
that's
The
already scheduled.
sorry. I just placed the question, then you answer. If after 10th January somebody leaves, now those seats are vacant. So what do you do with that seat? It will be remain vacant.
It will remain vacant. And once they can go up to the apex court and file an application in the matter.
The extension can be made by the Honorable Supreme.
Lord, may I clarify with my limited knowledge? I tell you, Lordship, Lord, a matter was
Your
taken up.
lordship has put a pointed query. No, I did not interject.
May I answer the
Much
court's
prejudice
query?
you have caused.
Somebody will get it.
Very good.
Yes, let him say.
ঝগড়া করো না দাদা।
No.
ঝগড়া
Much
করো না।
prejudice you have caused. You have given sufficient time. So I did not interject. Single word I have not stated. The fact remains, my lord, in what manner the fact has been posted. This is not the correct fact. Kindly have a look at the writ petition once.
Lord, I will be failing in my duty if I don't show one paragraph from the affidavit in opposition. Then let him take over. Just
No,
this
I
time,
am only
because I could not conclude. Let me conclude, my lord, on the affidavit in opposition. Then let Mr.
So since it is a hearing, you can post it matter.
Mr. Dotto, please.
It is a
Lord,
matter
kindly
of
take
life
the-
and death of a student.
Yes,
my
yes,
lord.
kindly take the
It is
affidavit.
not that the single bench passed
This
an order
way-
that has been affirmed by the honorable division bench.
Kindly take the-
Subsequently, the matter has been taken up by the honorable
kindly take note
coordinate
the
bench.
affidavit in
Coordinate
opposition.
bench considered the matter. Investigation is going on. What narration he is stating the fact, like my lord, all the investigation would be done not by the CID, by Mr. Chakraborty itself.
Lord, why this sort of
Because
personal
the
attack on-
state of West Bengal is there. We are not aware about the fact. They can apprise your lordship what is the stage of investigation. It is that, my lord, because the initial order,
One thing is there, the provisional admission is subject to the criminal proceeding.
Grateful, my lord, grateful.
But
This
20th
must
November,
not be in place.
but 20th November says as per the format. Format, if it is
Format
not
is
there,
not a matter.
he cannot get a provisional admission.
But the order says that the provisional admission now all on a sudden, if you cancel, then where is the investigation done by the state?
Lord, there are two components. Initial order says that it will be subject to the investigation.
So it has
Sec-
to fall vacant.
Absolutely. Second, what the court said, that if he produces a proper format, then only he will get the provisional admission.
Format is not an issue at all.
This is the order. 20th November. Kindly come back to
He
the
is
order.
trying to, Miller, kindly, Miller.
Considering all this, he has been given a provisional admission.
With the rider that the format has to be correct. Kindly come to the 20th November order. Kindly come to 20th November order.
কারণ
once.
আপনি দিচ্ছেন কেন আমার তো সাডেন আছে
Have a look at 20th November order. Your lordship's file, 20th November order. Kindly have a look at.
রাখুন আমাকে দিতে হবে আমি দেখে দিচ্ছি
Kindly have a look at the 20th November order. Third page, the bold paragraph. The respondent number 3 and 8 are directed to complete the provisional admission of the petitioner subject to production of fresh bond within schedule today. One part. Second, subject to prima facie satisfaction of the respondent number 8 in the college regarding the veracity and format of the bond. So if the format of the bond is wrong, that will not be provisional admission, will not be given. That is the order. I show that.
Why did the college then provide a provisional admission?
Lord, he came at the last point. We have provided in the provisional admission, saying that it will be subject to verification. We have verified and coming to a lordship's court.
Miller, kindly give me
The order records. Lord, again, let me place it. The order records subject to regarding the veracity and format of the bond. We have checked out the veracity and format. It is not in terms of format. We have given the power by the court that we will do and confirm. But we have given him. He has said.
Mr.
Miller,
Chakraborty, you cannot interpret the order of the court as per your wish.
Great Lord, I am just trying to, Lord, assist your lordship. Lord.
Just follow again, read that order.
I'm reading it for my lord.
Yes, it is not that you give admission and then you check the veracity. It says that prima facie, after being satisfied of the veracity of the bond
and the
you take.
format.
Now you have issued a provisional certificate. Now you say that you cancel that, because the other persons are waiting in the line.
Now, what is the provisional given to him? Kindly have a look at that. He has given a declaration that he will not claim any right. Kindly come to that. His declaration.
Sir,
Supplementary থেকে বার করো।
college has been given the authority to check the veracity.
And the format.
Whatever declaration the student says, if I concede to what you have submitted, that there is a forgery done at the first instance when the bond was produced in court, and the CID investigation is going on. Now the provisional admission is subject to the veracity of the bond being prima facie satisfied by respondent number 8.
Absolutely, my lord.
Where
What
is
we
that
have said-
satisfaction?
What we have said in page 11 of the supplementary affidavit. Kindly take. Lord, just because I have given him admission on the last moment, that will not create any right in his favor, subject to correction by my lord.
Then you have not checked the veracity of the bond.
Lord, the format. Kindly have a look at page 11 of the supplementary affidavit. If my actions binds me, then his actions would also bind him. Page 11 of the supplementary.
My lord,
I clearly understand and acknowledge that my present admission is purely provisional and subject to verification of the submitted bond and in components as well as per the order of the Honorable Court. So we took some time to verify and we immediately came to court. Lord, the court said that it will be confirmed.
Okay. Yes.
my lord, may I be
No,
permitted to
only
file the
thing,
report?
let him submit the report by the the CID,
The
and
latest
thereafter
report
impress.
has on date, my lord.
তোমার পেপারে নাকি রিপোর্ট দেখাতে বলছি হি ইজ রিলাইং অন দ্য রিপোর্ট
বন্ধ করতে হলো।
Kindly have a look at. My lord, we have got the intimation from the report from the paper. He is saying that, my lord, whether I am ascertain the fact that whether what the report is saying, but it has been reported in the newspaper. May I read, my lord? Kindly see. That would be more authentic, I think. এই নিউজপেপারটা কেনা হয়নি, তুমি কিনে পড়ে না।
আচ্ছা আমার সঙ্গে ঝগড়া করে কি একটু লাভ হবে তোমার?
না।
এত পার্সোনালি নিয়ে নিচ্ছ কেন?
না পার্সোনালি তুমি বললে, তুমি কেন বললে যে আমি রিলাই করছি ওই ডকুমেন্টটা?
প্লিজ আর্গিউ উইথ দ্য কোর্ট, নট
My lord, kindly have a look at.
You are sufficiently senior, don't argue with me.
I have to take certificate from you.
ডিভিশন মিটে অর্ডার করে দাও।
কোটা দিচ্ছেন তো এটা আমাদের কখন থেকে করে দিই আমি সিআইডি রিপোর্ট তো
Yes.
My lord, kindly have a look at the writ petition. Page 17. একটু বসুন আপনি। Page 17, my lord.
Yes.
This is the prayer, my lord, prayer C. The writ in the nature of certiorari, commanding the respondent to forthwith quash and set aside the arbitrary and illegal demand of the bank guarantee. So bank guarantee has been sought for by the, my lord, the college authority from the day one. What is the purpose? The purpose is this: if the someone having been qualified in the counseling, he would be, my lord, he would be admitted. He has to pay 24 or 22 lakhs rupees for the entire period. If they would be able, in the state quota, if they would be able to vacate the seat, they will get 1 crore. This is not only vacancy,
It is only the purpose.
I have
only
to
the
strongly
purpose.
object to this. So a state quota seat, the fees are fixed by the Jyotirma.
Yes,
Justice
I am
Jyotirma
saying
Bhattacharya's
so. The state
authority.
quota I am telling.
State quota seat fees is 20 lakhs or 30 lakhs.
Yes,
It
whatever
can
might
go up to 1
that Milord, I am in the state quota.
Produce the document.
I am the state quota. Then Milord, whatever might be, the bank guarantee has been sought for. Therefore, we have sought for Milord the direction so that the bank guarantee would be waived. Kindly see the order, which has been Milord the filed in the supplementary affidavit, the first order dated Milord 11th of.
Now show me the letter by which the petitioner was directed to produce bank guarantee.
Milord?
Because he says that there is no.
Yes, I'm
going to show that. The petitioner was asked to produce a bank guarantee instead of a bond.
Milord, this letter is not there.
This is an admission in the medical college. Yes. There are certain guidelines which has to be followed. I cannot say that you bring such and such cash and deposit in my counter, in the college counter.
It is not that. It is not that.
Where is that statutory rule to produce the bank guarantee instead of bank bond? They say that there is no such statutory rule. One has to come with a bond and furnish the bond for the author.
Milord, kindly see, Milord. After filing the writ, kindly have a order dated 20th of November 2025. Milord, kindly see the supplementary affidavit. Sorry, Milord, the order which has been passed, disposing of the writ petition.
Page number?
Milord,
12 November order.
12 November order, Milord. This is the order dated 12th November 2025. Milord, there is no denial also. There is no denial on the part of the respondent. Kindly have a look at, Milord, the order. The affidavit of the service such and such, the petitioner being the successful candidate of the need such and such, had participated in the counselling conducted by the medical counselling committee of the respondent number 3 herein for the admission of the medical course in West Bengal. In the third round of the counselling, the petitioner was allotted such and such, Durgapur, the respondent number 8 herein under the unreserved category against the state quota, but he was denied the admission purportedly for the failure of the furnish of the bank guarantee. Such and such learned advocate of the petitioner submits that to get the admission of the allotted college is obliged to furnish bond, not the bank guarantee. Yes. Then, Milord, their submission.
Please read my submission. Please read my submission. Please read.
I did not interject. I did not interject. You have skipped. No, I am not. I have not been misled. I have not misled. I did not interject. No, I will not read.
Should I release the matter?
It has been said that I have accepted. I have said
why he dictate. He will dictate in which one
goes on. Either address to the court.
Yes.
Mr.
He is dictating me, Milord. He is dictating me that we have to read.
Please address the court.
I did not interject, Milord, while he was, Milord, submitting.
Yes.
Then, Milord, kindly see, their submission has been mentioned. Then, the petitioner is directed to approach the respondent number 3 and 8 with the said original bond to complete the admission process, and the respondent number 8 upon the production of the said original bond and upon compliance with the other formalities shall admit the petitioner, and thereafter the respondent number 3 shall regularize the said admission. So this is the order. After, Milord, passing this order, when the bond has been furnished on that day itself, whatever may be the, Milord, the authenticity of the bond, they file a, Milord, an application recalling the said order. This is, Milord, Can 1. So what is the scope of the Can 1? What is the prayer of the Can 1? Kindly have a look at, Milord. Kindly have a look at page 13. Hello, got it?
Wait, yes. Yes, Can 1, page 14.
13, Milord.
Yes.
In the premises as aforesaid, your lordship would graciously be pleased to issue a rule calling upon the writ petitioner and the other respondent to show cause as to why the order dated 12th November 2025. His principal prayer, 12 November 2025, passed by the lordship such and such, shall not be recalled, and the writ petition shall not be dismissed with cause, and or cause being shown, or if no cause is shown, to make the rule absolute, pass such other order or orders, and ad interim order in the terms of the above, Milord, the prayer. So principal prayer is recalling of the order dated 12th November 2025. Court passed an order staying this order. Kindly have a look at. No, just 17 November 2025 order.
The affidavits in the writ petitions have been filed.
No. A writ petition was disposed
Writ
of on the first.
petition has been disposed of. And
All the affidavits and the supplementaries pertaining to the CAN 1 application.
Not in the writ. Writ petition has already been disposed of, my lord.
And the affidavits are only with regard to supplementary, no affidavit filed against the application. It's only against the supplementary affidavit.
Now you are referring to which, sir?
My lord, the order dated, my lord, 17th of November 2025.
Yes.
Kindly have a look at, my lord, page 3. No, prior to that, my lord, page 2. My lord, there was a principal allegation in the, my lord, their application for the recalling that the forged document has been submitted. At that stage, it was simpliciter an allegation. Since this is an allegation, therefore, court passed a direction to file an FIR, and on the basis of which the matter can be investigated with. If it appears that in the criminal investigation department, there is a finding that the forged document has been obtained, and there is a contribution on the part of the student concerned, in that event, my lord, the admission which would be given, that would not be given effect to. This is the basic principle. So, my lord, it has been stated, page 2 in the order dated 17th of November, the Mr. Chatterjee learned senior advocate, the last parameter, Mr. Chatterjee learned senior advocate for the petitioner submits that petitioner is not shying away from any investigation, but the allegation is yet to be proved at this stage. The college should not put the career of the bright student like a petitioner at stake. Heard the learned counsel of the parties peruse the materials on record. In view of the letter being number such and such dated November 14, 2025, the head clerk of the office of the chief judicial magistrate being the first class judicial such and such, a prima facie doubt regarding the genuinity of the bond executed by the petitioner has been created. Therefore, the direction of the court upon the West Bengal Medical Council Committee and the college authority respondent number 3 and 8, respectively, to complete the admission process of the petitioner upon production of the said bond shall remain state until further order. The respondent number 8 is directed to lodge a formal complaint with the jurisdictional police station, Bhavanipur police station, regarding the alleged act of forgery in execution of the said bond. The original bond produced by such and such and over the Mr. Chakraborty for keeping the same in the custody of the respondent number 8 college, so long it is not requisitioned by the police authority, photocopy thereof be kept with the record, the application for the fired directions be listed such and such. Then, my lord, kindly have a look at the order dated 20th of November 2025. My lord, I will place, my lord, the third page, my lord, of the said order, which has been, my lord, challenged subsequently before the division bench. Heard the learned counsel for the parties peruse the material on record. Today, in the last date of the admission, the bond produced by the petitioner to get admission prima facie appears to be forged document. So, court is conscious of the fact the document which has been produced is a forged document. However, the involvement of the petitioner in the act of such forgery is yet to be established. Therefore, it will be inequitable to deny his admission at this stage. Court is conscious of the fact the document has been forged. Court is also conscious of the fact that what is his role to be played has to be ascertained by the investigating agency. The respondent number 3 and 8 are directed to complete the provisional admission of the petitioner subject to the production of the fresh bond within the scheduled time today, and subject to the prima facie satisfaction of the respondent number 8 regarding the veracity and the format of the said bond. So, the principal thing which is required to be considered, that, my lord, the respondent has been directed. Then, next para, the admission of the petitioner, there is a rider. The admission of the petitioner is subject to the final outcome of the pending criminal proceeding, not format, pending criminal proceeding. In the event the petitioner is found guilty, the said criminal case, his candidature seat allotment shall be cancelled with immediate effect, and in such event, the petitioner will liable to compensate the college as per the bond. So two aspect has been taken care of. If, my lord, there is a cancellation, if he is found guilty, in that event there would be a cancellation of their admission. At the same time, he would be obliged to recompense the loss sustained by the bank, sustained by the, my lord, the institution. So both things has been taken care of. This is equitable order. The petitioner, if he fails to produce the fresh bond today within the stipulated time, the direction of the block of the seats allotted to the petitioner shall stands vacated. Such and such shall be at liberty to put the seat in the next round of the counselling, such and such. Next is important. The DIG CID West Bengal is requested to take over the said Alipur police station case number such and such dated such and such immediately. A progress report of the investigation be filed before this court on the next date of hearing. So court is also, my lord, conscious of the fact that what would be the development of the investigation to be proceeded with. So that's why the matter has not been disposed of. The matter is listed on such and such. Parties to act on the server copy of the order downloaded in the official website. Urgent photostat certified copy. This order has been, my lord, propriety of this order has been challenged before the Honorable Division Bench. This has been argued at length. I was there. It has been argued on length. And, my lord, subsequently, kindly have a look at, my lord.
Yes.
Page 2. Page 2, my lord, of the order dated 26th of November 2025.
Just now he handed over a copy. You have a copy.
Miller, I do have set. Kindly see. This is the, Miller, this is the set of, Miller, all the orders. This is the set of all the orders, Miller. Your lordship will get it chronologically. This is order dated 26th of November 2025. Passed by the Honorable Division Bench. May I refer, Miller? Miller, kindly have a look at page 2. Mr. Kaur, second paragraph. Mr. Kaur, the learned senior counsel, who appeared for the appellant, appearing for the appellant, submit that the bond which was produced by the writ petitioner at the time of the hearing of the writ petition on the 12th November 2025 was a forged document, as would be explicit from the documents annexed to the pages 102 and 103 of the stay application. Having produced the such forged document, the writ petition could not have been claimed any equity, and the learned judge erred in law in exercising the discretion in favor of the writ petitioner. He submits that the learned single judge erred in law in directing the admission beyond the mandatory period specified in the such admission on the 6th of November 2025 and 8th of November 25 till 4 p.m. Such and such learned advocate appearing for the writ petitioner, the respondent number 1, denies and disputes the contention of Mr. Kaur and submits that there is no infirmity in the order impugned, inasmuch as the learned single judge has categorically made it clear that the provisional admission as directed would be subject to the outcome of the investigation in Alipur police station case number such and such. In reply to such and such, Mr. Kaur submits that the bond which was furnished by the writ petitioner pursuant to the order dated 20th November 2025 was not in form and not in consonance with the direction contained in the order. So this issue has been agitated that this is not in proper format before the Honorable Division Bench. Answering the query, Mr. Maiti, learned advocate appearing for the university, submits that the counselling process has already been completed. We have heard the learned advocates appearing for the respective parties and considered the material on record. By the impugned order, the learned single judge, this is important. By the impugned order, the learned single judge has directed the admission of the writ petitioner subject to the final outcome of the criminal proceeding. Pursuant to the such direction, the writ petitioner proceed a fresh bond before the appellant and he granted provisional admission. It thus appears that the order has been acted upon. Furthermore, the record should reveal that the writ petitioner has been made returnable tomorrow, 26th of November 2025, under heading to be mentioned. In this conspectus, we are not inclined to interfere with the order impugned, and accordingly the appeal along with the connected application is dismissed. So everything has been considered. It is, however, made it clear that the dismissal of the appeal shall not prevent the appellant to advance the argument and such, and then there is no order as to costs. So that has been mentioned. So, my lord, All these point that this is not in proper format has been taken care of, that has been argued before the Honorable Division Bench. And Honorable Division Bench is conscious of the fact that investigation is on and that consideration is also there. Then, my lord, kindly see the order in the can at page, my lord, 27th of November 2025.
Yes, yes,
The supplementary, then, my lord, the scope of the can 1 has intended to be expanded when they did not get any order before the appellate court by filing a supplementary affidavit. What was the proposition? That, my lord, the subsequent bond which has been submitted not in proper format, although that bond has been examined by them. A supplementary affidavit is filed on behalf of the such and such is be kept with the record. The petitioner is a successful candidate of such and such, was allotted with the seat of such and such, respondent number 8 herein. The bond submitted by the petitioner at the time of the taking admission of the said college was found to be forged document. The college by the present application has brought the said fact on the record. Court by the order dated November 20, 2025 has directed the college to lodge a complaint with the concerned police station. The college, in compliance with the said direction, has lodged the said complaint giving rise to the Alipur PS station case number such and such. The said criminal case in the terms of the direction of the court is taken by the DIG CID West Bengal. A progress report of the said criminal case in a sealed cover that has not been opened, that has been placed before this honorable court, is filed on behalf of the state. Let it be kept with the record. Court, however, by the order dated November 20, 2025 has directed provisional admission of the petitioner subject to the production of the fresh bond within the scheduled time and subject to the prima facie satisfaction of the college regarding the veracity of the format of the said bond. The college of the supplementary affidavit filed today alleging that though a new bond was submitted by the petitioner on November 20, 2025, but the same was not in the proper form, but to comply with the direction of the court, the petitioner was given provisional admission. It was not the order. Order was, having been satisfied with the format, you give admission, provisional admission. Then, my lord, the submission of the Mr. Kaur has been mentioned. The court, the learned senior advocate for the counseling, submit that the new bond is defective as both the parents did not put their signature in the said document. As such, the said bond is not a proper, and as such, on the basis of the said bond, the petitioner cannot be admitted. His praise immediate suspension of the admission of the petitioner. On that submission, my lord, father and mother of the student has given a subsequent bond, where, my lord, father's signature is there, mother's signature is not there. What was the bond? It is nothing but the indemnity as per, my lord, the section 126 of the Contract Act. So it has been stated 124. So it has been stated that if he is having any property, he has to give it as a collateral security. The property which has been given, that is not stand in the name of the mother, that is stands in the name of the father. So they erroneously, my lord, since, my lord, he is a day labor. Since he is a day labor, my lord, he is not in a position. He has to approach the learned advocate. If the learned advocate in what manner they will guide, he has to do it. So what he is staying, my lord, he is doing in Calcutta, in Durgapur, in Baharampur, we are not aware of the fact. Only see, Mr. Aniruddha Chatterjee, learned senior advocate of the petitioner, submits that the petitioner at least is entitled to chance to controvert the allegation of the supplementary affidavit before any penalty is imposed. So since, my lord, further allegation has been made, an opportunity has been sought for as to why the allegation has been made. Then, my lord, this is the observation. The admission of the petitioner is provisional. The acceptability of the bond produced by the petitioner to get such admission needs to be decided first before cancelling the such admission. Therefore, the prayer of Mr. Kaur for immediate suspension of the provisional admission of the petitioner at this stage is refused. The petitioner is directed to affirm an affidavit in opposition and such to that effect. So kindly take, my lord, there, my lord, supplementary affidavit. My lord, similar matter has been taken up, Justice Basu, and passed an order where the similar issue was cropped up. He belongs to a marginal section of the society, where, my lord, the similar issue has been came up before the consideration, where, my lord, the father has filed a bond which has been accepted by the college and court and passed an order. This is the similar order. So it is not required that father and mother has to file the bond. The property stands in the name of the father. he would be the guarantor, not the mother would be the guarantor. But it দিয়ে দিচ্ছি একটু দেখে আমি তোকে দিয়ে দিচ্ছি
At least give me the number of the case that you can say.
এক্ষুনি তোমাকে জজ সাহেব দেখার পরে দিয়ে দিচ্ছি
I'll check from the online. You don't have to give me the date.
না আমি কোনো ফোর্জ ডকুমেন্ট দিচ্ছি না
Your client can give, no? That's his conduct. Please tell me the case number. Let me check from the website.
Which paragraph?
মিলর আরেকটা কপি আছে ও মিলর দি
You can tell me.
হ্যাঁ কেস নাম্বারটা নিয়ে নাও 27446 of 2025
The candidate has the choice preference of giving a bank guarantee or a bond. My lord, I am representing WBMCC. We have a notification dated 7th August 2025. Roman 2. My lord, I will hand up my tab. I don't have a printed version. Sorry, my lord. It is written clearly, candidates who are getting admission in private college, trust colleges, central institutes have to submit the bond/bank guarantee as per requirement of the said college. In
requirement
that
of
case, it's written preference to be given to candidate's choice for providing bond or bank guarantee. So it is basically the candidate's choice.
So there is a provision for giving bank guarantee as well as but they insisted, my lord. That's why a person will not come and my lord, they knock the door of the court.
What the MCC is referring, this is the notification.
My lord, 11, 12, 13. My lord, 11 onwards.
কত তারিখের অর্ডারটা দেখাচ্ছ তুমি অর্ডারটা যেটা
My lord, Roman 2 at the end of the first page.
11th of December 2025.
Roman 2.
Candidates who are getting admission in private colleges, trust colleges, central institutes have to submit the bond/bank guarantee as per
So
requirement.
there is a provision of the two things. So that's why they have insisted.
It is as per the choice of candidate.
he had to show that he had a bond to show that we have
So, my
insisted.
lord, nobody will not knock the door of the
Submitted
court.
that there is a statutory norms that one has to submit bond.
Yes, that I have shown me on page 53 of the writ petition. That the bond he
No,
has to
kindly
come.
see the paragraph 11 onwards, my lord. Paragraph 11 onwards. Where, my lord, this provisional admission has been given. After giving the provisional admission, he filed a bond. This bond has been submitted by the father alone, and that has been accepted. And the pro forma which has been given, my lord, in other college, Jagannath such and such. Jagannath Gupta ki. This is the pro forma.
বন্ডের ইস্যুটা কোন প্যারাগ্রাফে দেওয়া আছে সুবোধ একটু বলবে
ওই 11 থেকে সব লেখা
You can stop here. We'll take the matters after the vacation. Heard Mr. Srijeev Chakraborty, learned advocate for the petitioner. Mr. Chakraborty, learned advocate for the call list. Response number 8, nahi ho? Response number 8 submits that at the first instance, the bond which was submitted by the petitioner was primarily found to be forged. Upon scrutiny, though on the basis of the said bond produced in court, the writ petition was disposed of
on 12th November 2025.
12th November 2025. On the assumption that the bond is in proper form. An application being, can one is that application for recall?
Can one of
Application being can 1 of 2025 was filed before the court for recalling of the order since the bond that was furnished was found to be forged. The court directed for criminal investigation, which is under process. As per order, which order this provisional admission has been given?
20th November.
20th November.
20th November 2025, provisional as admission has been given to the petitioner, which is subject to the veracity of the bond.
And format of the bond.
And veracity and format of the bond. Upon scrutiny, it is found that the bond has not been executed by both the guarantors.
My lord. My lord.
Both the guarantors, and as such, it is not in proper form. Since the order of this court for provisional admission has not been complied with in stricto sensu, the such provisional admission needs to be cancelled forthwith. Mr. So and so learned advocate, on the contrary, or the petition on the contrary, submits that the order granting provisional admission has taken care of the consequences which can crop up due to such admission. And it has categorically subjected such provisional admission to the outcome of the final outcome of the criminal proceedings.
My lord.
And furthermore, condition has been imposed that in the event the petitioner is found to be guilty, has to compensate the college authority. Similar submissions were advanced before the Honorable Division Bench as well as before the coordinate bench of this court, which has refused to cancel the provisional admission. A report has been furnished by the state. It is found that investigation is still going on. Since the provisional admission of the petitioner is subjected to the final outcome of the criminal proceedings, at this stage, it would division bench
The division bench has returned everything back to your lordships.
decide everything after it is now page 3.
No, order of compilation, Milord, this is order dated.
3.
Order dated 26th of November 2025.
When this which for the state?
State is
So what is the stage of investigation and when it is going to end?
It will take some time, but
How long?
all the culprits.
Culprits again. All the culprits. Accused.
It will take some time.
Sir, kindly specify the time because yes,
3 months.
What is the stage of investigation right now? How many persons have been, whether it has been sent?
One person has been arrested, my lord, and investigation and the other members of the racket, as well as the trace of both seal and stamp, that is in progress only. My lord, kindly come to my lord.
Report the
Paragraph 3, my lord. Of the report, my lord.
It has been observed in order dated 27th November 2025 that the acceptability bond produced by the petitioner to get such admission needs to be decided at the first instance before cancelling such admission. Accordingly, let the matter be fixed on. বলুন জানুয়ারি অ্যাসাইন কবে নিচ্ছি থার্সডে
কবে Thursday is 8th of January.
8th of January, I'll take it up. You have concluded your argument with regard to the bond that is given.
Nothing. Lord, I have nothing more to say. Only one paragraph from the affidavit I'll show that I could have shown today. I'll show it on 8th of January.
Miller, I am
Our
paying for the
endeavor, Lord, our endeavor is never to
Can NMC regularize his admission then?
Why?
Lord, that is not that we are challenging. They cannot regularize it now.
How can
It's a provisional admission, my
Yes, they cannot be regularized. You know,
register his name on the portal.
Lord, your lordship is deciding the admissibility. Then it will tantamount to Lord dismissal of my application. What the state is saying, the court is Lord adjudicating.
No.
the issue.
Miller, may I submit? May I submit, Miller?
Lord,
Initially on 15th or 16th, Miller, he visited the college. Despite Miller, there is a provisional admission. He was not allowed to enter into the premises or
He's
precinct.
saying wrong things.
Subsequent,
Again, he is saying wrong things.
we are having Miller the document with me in supplementary affidavit. I will file.
I'll show
Then
the
Miller on 17th he has been allowed. I have written. He visited college on 8th of December 2025. He has been refused to enter into. 10th of December 2025, he has refused to enter into. On 17th of December 2025, they asked me to come to the college. I went there. I have been allowed. Then, Miller, I have been allowed, allotted the hostel. Since then, from 17th, I am doing the Miller college.
Yes.
This is the Miller the development.
It is the duty of the college authority, my lord, as per
From the day
regulation
one.
made by the National Medical Commission. Well, since it is the admission regarding my lord MBBS, well, it is the duty of the college authority to forward the name of the candidate who has got admitted.
But we are challenging the admission.
MCC Medical Counseling Committee.
They are not forwarding.
We are challenging his admission.
Otherwise, if ultimately, my lord, the student is found not guilty, my lord, he will not be registered in the
University.
as well as the ultimate after.
Lord, we are challenging his admission. If that is done, then everything will go out of hand. We're challenging his basic admission.
Was the order when it was found, any such submission was advanced
No,
before
no,
the
no,
court
no, no.
that this is a predicament
No.
to give a provisional admission. On the
No.
basis of provisional admission, there
No.
is no registration.
Nothing was said.
Since we are, my lord, on behalf of the respondent authority, we are trying to assist your lordship.
But they were on
Come
that
up
day.
with a proposal, what to do then?
Yes.
But we
They have
can
he cancelled the provisional admission cannot be granted as an admission
Yes.
because there are
then-
matters which is to be looked into.
Yes.
So, Milord, if Milord, they will forward the
kindly
name. That
consider
will
one
not create
thing.
any prejudice.
Kindly
because
consider
this
one
being
thing.
what?
Lord, kindly consider one thing.
But I have not decided it.
Yes, your lordship is deciding it. Now, how can the state comes up and say this?
is,
State, Lord, how, Lord, the state has become very conscious about the student.
lock the seat, my lord, for long.
State has become very concerned about the student. They did not come. They have never
state has
taken a
to be,
step.
because the state is having
Yes.
parent
Decided by the court.
Yes, till the matter is decided by the court. It could not be done. Not only one thing can they consider.
Since
If
there was
Petitioner will come after us after certain point.
the matter is pending in court, why will you be obliged?
when my order has been given, he has not been allowed to enter into the Milord the
Lord, that is a wrong
college.
statement.
No,
that is a
on
wrong
affidavit I can give it.
I will
because
also
I have
file an
taken
affidavit.
note.
Mr. Dotto is
Milord, I
taking
have
a wrong statement.
taken written note, Milord, from
I have also taken
because
a
we have sent Milord. These are the mails. Milord,
Yes,
kindly
I have
see.
the copy of the mail. Email to
Milord, kindly see the mail.
I have a copy of
We
the
have sent it. We have been
Lord,
refused.
his phone was switched off for 10 days. He did not come.
ব্যবস্থা করে দিয়েছে।
Why we are fighting for this? Your lordship is keeping it after vacation. We can come and argue all
Kindly
this.
see the mails, Milord, we have sent.
We can come.
Not
Why?
see anything until and unless it is
Yes.
filed
We'll
by way
come
of
back
an
on
affidavit.
8th of January.
File that.
Lord, we'll come back on 8th of January.
File a supplementary affidavit.
My lord.
Mr. So-and-so learned advocate submits that the petitioner has been prevented to attend college.
My lord.
Which we have denied. which I am denying.
Which is denied by Mr. Chakraborty, learned advocate for respondent number 8, College Authority.
Yes.
And subsequently, my lord, I have been allowed on 17th. On 17th.
Yes, I have prevented, I have allowed.
Yes, because my lord, I do have mail and I have to have intimation.
After the criminal case was registered, he switched off his phone and
Filing any
went there.
affidavit?
Yes.
My lord.
Will you be filing any affidavit?
So, my lord, this is not German over
No,
here.
my lord,
because
this is kindly let him file it.
Sorry,
Yes, then.
No, I am showing the conduct, my lord. I am showing the conduct.
Please look
In
into your
what manner
conduct.
they
You
are,
are a
my lord,
fraudster. If you had a fraud
No,
document
madam,
that
what
came
is the
to
technical problem? Since there is a order of this court,
yes, ma'am.
which everybody has to abide by that order.
Yes.
It says a final outcome as
Yes.
well as the veracity of the bond, which
Yes.
has not been decided. Now the affidavits have been filed. I am fixing a date on 8 to conclude the hearing
Yes.
with regard to the veracity of the bond.
My lord, my lord. On 8th of January, we will conclude the hearing.
Only tech problem will be in the future is that the portals will get closed which are open right now. Due to the
That your lords will direct for opening the portal if he succeeds. If he succeeds.
only predicament.
Yes, your lords will direct them.
Rights of the parties are involved. We cannot
Yes.
go by that
Absolutely.
timeline.
Your lords will direct.
Decide. Let this.
Being framed by the Honorable Supreme
No, that is for admission, not for registration.
As this case is concerned, since he has been provisionally admitted to the
Yes.
college,
Yes.
now the matter has to be decided by the court.
Yes.
Till such period, the provisional
Absolutely.
admission should be extended.
Yes. And I'm grateful to lords. Well, let us come back on 8th of January and we'll complete the argument.
NMC and the WBMCC were thought that we will also register his name in the portal provisionally.
if the order goes against him,
We will
immediately
cancel
cancel.
because it's easier to file to cancel.
So what is the difficulty now?
No, they are not forwarding the name. They are not forwarding the name.
Lord, that is not the issue before my lord. Let us come back on 8. That is not the issue. It is coming verbally from them. That is not the issue. Let them produce if anything is there. It's a provisional admission. We have challenged that.
The provisional admission has been made.
Lord, the provisional admission has been made as per the court's order. Lord, as far as my limited knowledge, let me explain this. Lord, normally the admission is done through the online problem. His time of admission expired on 8th. Then he went there on 20th with
So
order
he,
of the
once again, my lord, he
he went there on 20th for physical admission. So there was no online admission for him. We have physically, provisionally admitted him. And immediately on the next day, we have challenged his admission before your lordships. Now, the Justice Basu said, let the provisional admission continue and the issue shall be decided. Now, today, if your lordship directs that his admission shall be regularized, then that will tantamount to dismissal of my application.
There is no question of regularization.
No regularization. We are not seeking any regularization.
One more thing. Lord, one more thing.
Provisional entry into the formalities. That would be did provisional.
With regard to the, I do not know why the state has become state.
See, you maintain these circumstances which was before Justice Basu. We'll continue on 8th.
Yes.
Conclude your hearing and we'll decide on this.
Instead of 8th, minute, can it be the 9th or minute, any given 9th? Because I'm 9th, if your lordship pleases. 9th আছে দেখুন তো একটু প্লিজ
9th.
More than 6th.
No, 6th.
Wait. Monday তে দিয়ে দেবো? হ্যাঁ?
13 করুন
12th.
আজকে তো টুইসডে
On 13th, Mr.
Kindly make it on 10th because up to 11th the portal is open.
10th is a Sunday or Saturday?
Then 9th ही करो portal open.
সুবোধ ম্যানেজ করো না 8 তারিখ দেখো
9 তারিখ করুন 9 তারিখ করুন
No, 9th minute. Make it 9th. Make it 9th minute.
Okay.
Lord, I am here every day. My lord, whenever my lord calls me. Lord, our endeavor is to clean the system. We are not against anybody.
Okay.
If he had not come with on the first day, what Mr. Dotto was saying, I only impressed upon the college that you give him admission. Because I thought it was a genuine bond. Lord, a person, if this goes on, Lord, our apprehension is this goes on, from next year onwards, this will become a trend. People will forge documents,
Apart from
get,
this, minute, other
get
categories
admission,
also been done. The
get admission,
similar sustain.
and then say that subject to the result of the criminal will never end.
How long you will take to conclude?
Half an hour.
Yesterday he said 5 minutes.
For me,
এগিয়ে নিন তাহলে সুবিধা হবে 9th is the last date. একটু এগিয়ে নি তাহলে। On 6th, sir, who was having problem on 8th?
6th minute, 6th.
Huh?
6th.
Okay. 6th.
Always in front of your lordships. No
On
problem
6th.
with it.
Okay. On 6th, sir.
My lord.
Okay, thank you.
We are grateful, my lord, for giving us, my lord, patience
Thank
hearing,
you.
my
Thank
lord.
you. Conclude on that day. And
Sir, kindly have a wonderful vacation.
same to you. Merry Christmas.
Merry
Merry
Christmas.
Happy New Year. We meet after the vacation.
Absolutely.
Thank you.